না থাকে Senior banks to heavy eyes, no? Only question. আর নতুন মেকআপ লাগবে তাকে মিস করবে তাকে মেনশন করবে না আর বোর্ড কাছে করবে রাইট জাস্ট a notice. Okay, mention go ahead.
I beg to mention item number 27. This may go to appropriate bench because earlier two of the co-accused were not granted bail by the Honorable Justice M.K. Kolita. My learned friend is there, man.
Your Lordship, I appear for the DRI.
Dear.
My name may be recorded.
On the prayer of the learned counsel for the petitioner, the matter may be listed before appropriate bench. The name of the standing counsel DRI, your good name,
D. Bora.
D. Bora, may be reflected in the cause list.
No, Your Lordship.
The next dates.
Your Lordship, in this particular order. In this order, Your Lordship, my name may be recorded.
Yes, yes.
My presence may be recorded.
Yes, yes.
May I please,
And he has appeared today, D. Bora. His name may be reflected in the cause list.
may I please, Your Lordship, I beg to mention item number 45, Lordship. In this case, Lordship, CD was called for, CD was not there for that. This matter may be explained.
CD not received, man.
45. Issue fresh reminder for the case diary. Interim is there?
No,
No. List the matter on
On my lord, 12/11.
Okay, fine. Not late.
oblige.
May I plead the lordship, my lord, a bail petition has been filed on last Wednesday, my lord. It has not been listed. May I pray that it may be listed on Monday, my lord? Not this Wednesday. Last Wednesday it has been filed, my lord.
I can take the mention. Senior bench, not necessary.
Yes, this is less than 7 years, my lord. Oblige, my lord.
May it please your lordship. Lordship, I beg to mention for listing of two bail application for motion. Lordship, earlier they have filed the bail petition, but it was rejected by your lordship. And lordship, on Tuesday, lordship.
Tuesday?
Oblige, lordship.
May I please, your lordship? I beg to mention item number 43, lordship.
43.
Kindly adjourn for the day, lordship.
Diary is received. Are you on interim?
Yes, your lordship.
So, the petitioner counsel seeks an adjournment for the day. So diary, case diary receipt shall be retained. Interim bail stands extended till the next date of listing. We can fix it on Tuesday or Wednesday? Tuesday or Wednesday? Okay.
Oblige, sir.
28 then.
Oblige. May I please, your lordship? I beg to mention item number 26.
Just a minute. আগৰটো কিমান আছিল 40 43 26
26, lordship. Allow us further 1 week time to file our objection.
kindly the standing counsel the learned counsel appearing for the NCB seeks another week's time to file their written objection. Prayer is allowed. List the matter on when do you want third
Any date after a week.
after week 3/11.
Such.
No.
Highly
You
obliged.
kindly inform that
Sir, I have taken consent from you.
consent of the other side has been taken.
May I please, lordship? I beg to mention item number 38. Lordship, CD is not available. Kindly,
Another
interim may be continued.
case diary is not received. Issue reminder. Your interim is there. Interim bail is there. Interim bail granted by order dated so and so stands extended till the next date of listing. This is the matter on
14/11, man.
bail. Also, interim is there, no problem. 14/11.
Oblige, lordship.
May I please, your lordship? Lordship, I beg to mention item number 67, my lord, of daily list. For upgradation, my lord, can it be fixed at 2, my lord?
67.
67, my lord. 10 years conviction is there, my lord. He is behind bars for 2 years, 10 months, my lord. Moreover, he is very sick, my lord, behind the bars.
Last matter.
Last matter, my lord.
Will it be possible to upgrade?
At 2, my lord.
It depends on the how it progresses. We'll try to take it up in the second half. Adjust it in between. Okay.
Oblige.
Because because there may be other
May-
matters also.
May I
which are
please, your lordship, I
urgent.
beg to mention for listing of interceptory bill, lordship.
New matter.
New matter, lordship, motion matter.
List before the, mention before the senior bench. Okay, as per
Right.
notices also. Mention before the senior bench.
Ma'am, please, your lordship, I beg to mention item number 39, lordship. Perhaps up-to-date case diary was called for, not received, lordship.
Case diary is not received.
I'm
Should
not on
remind-
interim, lordship, kindly.
To reminder. So, diary is not received.
Not received, madam.
Issue-
Along with FSL, lordship, kindly solve.
The issue reminder for the case diary along with FSL report, interim bail granted by the order dated.
I'm not interim.
Yeah, I think not. Category. Please the matter on.
On my lord, 311.
Can it be on 30 or 31st of October?
30 will be tight position actually. Anyway, okay, 30. 30.
My pleasure. Also, I beg to mention item number 40, my lord.
Hmm.
My lord, CD was called for, perhaps CD not received, my lord. I am on interim, my lord.
40 CD not received, madam.
Case diary, issue reminder for the case diary. Interim bail, right order dated, extended till the next date of listing. List the matter on
On 1511 only.
15/11.
Deeply.
May I please, your lordship?
Oh, just a minute, just a minute. 15 is Saturday.
Sorry, madam. On 1411.
Yes.
14.
14/11, huh?
May I please, your lordship, for listing bail application, the punishment is below 7 years, lordship.
I think new, below 7 years I can. The above, actually, below 7 years is my bench. New matters 5, no? There for equal to. Or less than or equal to 7. The senior bench to complete. More than 7. New maths, okay. So it's below 7 years.
Lordship.
May I please, your lordship, I beg to mention item number 20.
No, 20.
20, lordship, case diary not received, lordship, this matter may be fixed on 4th, lordship.
In this case, lordship, I am for the petitioner, lordship, let there be the last chance, because lordship, several data has been given to them, lordship. And moreover, lordship, it is a case of lordship 67 notice, lordship. As per notice, lordship, we will comply, lordship, nothing recovered from us, lordship. Since it is a lordship, commercial quantity that is recovered from the co-accused, not the co-accused on the basis of.
Commercial quantity section
Yes,
is there.
lordship.
Yes,
You
lordship.
have to see
On the
it.
last chance, lordship.
Investigation is going on, lordship.
Well, even if I say last chance, will the
Not
court
to-
be able to decide a 37 application without case diary?
37, lordship, if it is not lordship, recovered from the present petitioner only because of
No,
the
no,
statement of the co-accused, lordship.
Commercial quantity section is there, 37 is applicable, and can I decide without the
Lordship,
case diary?
67, lordship,
Case
that's
diary.
only.
I
if
also
I'm-
have my accountability. right?
Yes, lordship.
So, it's not like that. So you get the case diary. I
We
can
will
insist
produce-
on that.
On 4th,
That I can
lordship.
insist. Of course, the court will need the case diary, but I insist on that. Can I get, fix it on 3rd?
Lordship, he will, officer is on leave, lordship, he will join on 3rd, lordship.
Diary has to be just sent, What is
Okay.
the date?
No, 4th,
4th, item 20.
20.
The case diary is not received. The learned counsel for the prosecution within bracket NCP 6 another date, 6 a week's time for the same. Mr. Chaudhary, learned counsel for the petitioner, submits that already several dates have elapsed. The prosecution shall get the case diary positively on the next date. Full stop. List on 4/11.
4/11.
Even if he suppose he extends the leave also, just bring the case diary.
Lordship,
I'm not asking for a report, right?
lordship.
Obliged.
Harry,
May I please, your lordship? Lordship, I beg to mention for listing, lordship, a bail application, lordship.
Below 7 years? Below 7 years offense?
Eh,
If it is below 7 years, I can take, otherwise before the senior bench, which is Justice Nair, okay? If you're not sure, you can mention at 2 o'clock. Check it, 2 o'clock you can mention, okay, no problem.
60 days.
May please, your lordship. Lordship, with respect to item number 66, lordship, my humble prayer would be, lordship, the matter may be taken up before, lordship, rises some urgency is there, lordship.
66,
Supplementary last item, lordship. revision lordship, there is a delay lordship, that may be taken up before lordship
Right.
rises.
I'll try.
If it is recessed, then good.
No, no, no. Sure, sure. We'll try. Another matter is also there. We'll try both.
Yes, sir.
Item 37, my lord.
37,
Yes, Lord, matter will be taken on Wednesday, my lord.
Next Wednesday.
Yes, my
Diary not received. Diary has been received.
Item number 1, my lord.
37,
37.
Scan copy was called for, my lord.
or scan copy.
Yes, my lord, that has been received perhaps, my lord.
Notice should be there,
37 scan copy received, ma'am.
but notice,
Notice 37.
if notice is, if it's a case requiring notice, one, then together only we can
Yes,
make the
37, my lord, regarding 37 appeared, my lord, respondent on behalf of respondent
Yes.
on the cause list. my lord.
the,
Notice, sir.
as Islam Learned Council seeks an adjournment.
No,
Lays the
that-
matter on 29th, that means.
Okay.
To the scan TCR is available and scan TCR is available and Learned Council has also appeared on behalf of respond number 2. Okay.
May I please your lordship? Lordship is second bill application. Today is 75 days custody.
10-8, right? Chanmari please. So what was the allegation?
Whereas, my lord, this is
FIR is 14. My lord, earlier reject order page is 24.
This matter may kindly taken up along with item number 33. Item number 33 CD receivement. Same PS case.
Now 33 will take up. CD is already available.
May I please, Your Lord?
Yes.
Well, regular bail application, my lord, 36 days in custody. Allegation is, my lord, upon superstitious belief to be witch. Victim was subject to, my lord, torture, physical torture. This is the allegation, my lord, 36 days, my lord.
Which something act is there, my lord, serious.
Section 9, not less than 5 years conviction, may extend it to 10 years. That is, yeah.
Just
This is the allegation, my lord.
let me see the FIR. one.
I have suffered FIR, your lordship, my lord, translated part is not proper. Your lordship will find page 15, vernacular.
Read, you want to read that? Not very long.
Page 15, vernacular.
Writing is slightly.
1-5.
You can read it.
সন্মান সহকাৰে জনাও যে যোৱা ইংৰাজী 16/9/25 তাৰিখে পুৱা 7 মান বজাত দ্বিতীয় পক্ষৰ উল্লেখিত 10 জনৰ উল্লেখ কৰা শ্ৰী খগেন তাকুৱে মোৰ ঘৰলৈ গৈ শ্ৰীমতী মীনাৱতী মুদকৰ ঘৰত কিবা আলোচনা আছে বুলি কৈ মোক মাতি আনে মই তেওঁলোকৰ ঘৰলৈ আহাৰ পাছত মোক ডাইনী সজাই উল্লেখিত সন্দেহত উল্লেখিত আটাইকেইজন ব্যক্তিয়ে মোৰ ওপৰত অমানসিক নিৰ্যাতন কৰে. This is the crux, my lord. Subsequently, Gabula has appeared on the spot and he also tried to stop the torturing. This is the case, my lord.
Later portion is more important, my lord, last. কিন্তু গাঁওবুঢ়াই চোৱাচিতা কৰি নাই এনেদৰে মানসিক অত্যাচাৰ চলাই থাকি পুৱা প্ৰায় 9টামান বজাত দুয়োপক্ষৰ ৰাজীৱ মেধকে শৌচাগাৰৰ পৰা 20টা আনে আৰু সেই 20টাখিনি মোক খাবলৈ দিয়ে. So my lord, these are serious allegations, my lord.
খাবলৈ দিয়ে means not
Anyway,
My lord, section 9, my lord, your lordship, make not less than, conviction is not less than 5 years and may extend it to 10 years. This is the,
Well, my lord, the witch hunting act is there, my lord, always. offences
call
of-
for the case diary, third case,
36 days, my lord, the short date then.
I'll try.
60 days is the mandatory period.
Call for the case diary of special, okay, this is the number, special.
Especially, it will be my lord scan
WH
copy.
Case number
Vilamra PS.
2/2025 arising out of Vilamra Police PS case number, it is charge sheet.
Not charge sheet.
Not such-
Vilamara PS case number 33/25 registered under so and so section. Accused, present accused stated to have been arrested on 19/9/2025. The allegation in the FIR lodged by the alleged victim that the accused person's name therein had committed inhuman torture upon her with the allegation that she was a witch. The witch to it within.
WITC.
No, she didn't. Still prevailing in some place, backward places. Anyway. So, list the matter on
On my lord, 2910.
20 now, 2019.
I am of
Yes.
this.
May I please, Lordship, Lordship, 483 bail application, Lordship. Lordship, petitioner behind our last 52 days, Lordship. Lordship, allegation under section 305A and 331 surplus 4 BNSS. BNS, Lordship.
Yes.
Lordship, kindly peruse the FIR, Lordship. Lordship, FIR is space 16, 14, Lordship. May I read? Samit Barnikula. সন্মানপূর্বক নির্ত নিবেদন এই যে যোৱাকালি 18/4/2025 ইংৰাজী তাৰিখে মোৰ ঘৰত অনুমানিক 2 PM বজাৰ পৰা 5:30 PM বজাৰ ভিতৰত চুৰি কাৰ্য হয়। চোৰে ঘৰৰ মূল দৰ্জাৰ তলা ভাঙি প্ৰৱেশ কৰি মোৰ অলংকাৰ নগদ ধন পইচা পাতি গৰ্ডেজ ভাঙি লণ্ডভণ্ড কৰি মূল্যৱান সম্পদ লৈ যায়। কালি দিছপুৰ থানাৰ পৰা সকলোখিনি পৰ্যবেক্ষণ কৰি ফটো তুলি লৈ আহে। মোৰ ঘৰৰ পৰা গডৰেজ ভাঙি নেকলেছ 5 সেট, সোণৰ আঙুঠি 3টা, খাৰু 30 পিচ, পায়েল ৰূপৰ 4টা, সোণৰ লকেট 5টা, ৰূপৰ লকেট 4টা, চেইন আৰু লকেট 4টা, গলপতা 1টা, ৰূপৰ কইন 5টা, কাণফুলি 6 যোৰ, কেছ ₹500, কইন ₹500, পিতলৰ দাপনি এখন ₹500, সীতাহাৰ এটা, 2টা বেগ ₹1000 and documents আদি বহু
Many
মূল্যৱান
things have been taken.
সম্পদ লৈ যায়। Lordship, now the fact is that, Lordship, the petitioner is the daily laborer, Lordship. 1/9/2025, petitioner went out from his house and he was on darkened mood. As the co-worker beaten him and called the Dispur police and handed over the petitioner. And subsequently, Lordship, 1/2/9/2025 at about 11 PM, the Dispur police along with the petitioner visited the rented house, room of the present petitioner, that is near downtown Horumoti, Dr. Zakir Hussain Road. And nothing has been recovered, Lordship. And thereafter 1/3/9/2025, he was forwarded before the CGM Kamrup Metro. Lordship, nothing has been recovered from the present petitioner. No, moreover, the petitioner is not the FIR name request, Lordship. Lordship, I am allowed to go on the length of petition, Lordship. Lordship, mandatory period is 60 days and today 52 days completed, Lordship.
Is it? Just a minute, I'll, please. Was arrested on suspicion and having been found in suspicious manner near the location. When can you get the case diary?
Yes, there, my lord, from
Is
Dispur
29 be possible?
29, yes, I will try.
Call for the,
Lordship, but length of detention already 52 days first study, Lordship.
just let me see the 28 or 29.
28, my lord.
28.
Dispur from Dispur.
I call for the case diary of Dispur PS case number 721 of 25 under so and so. The accused was arrested on 3/9/2025. Learned counsel submits that besides being not named in the FIR, there is no recovery from this petitioner, and that he may be allowed to go on bail on length of detention. This is the matter on 28/10. If it comes, otherwise we'll see.
Bless, bless.
On that day.
May I please your lordship? Lordship, it is a regular bail application and I am more than 125 days in judicial custody, lordship. Lordship, I am charged with under section 1031, 109, 329, 3, 1172, 328 and 35 of BNS, lordship. Lordship, it is a search sheet, lordship, and I have submitted the search sheet, lordship. Kindly go to the annexer 4, page number 20, lordship. Lordship, I want to read the summary of the investigation, lordship.
Yeah,
Lordship, lordship, kindly go to the page number 32. Page number 32, lordship. The investigation has reconstructed the sequence of events that transpired on the fateful night of June 14, 2025 at approximately 11:30 p.m. within the residential compound shared by the families of two brothers in village Raitkusi. A brutal and premeditated act of violence unfolded. The accused person, accused 1, Sri Hemant Talukdar, and his wife, accused 2, Sri Zonali Talukdar, driven by a long-smearing and acrimonious dispute of her ancestral property, criminally transferred into the courtyard of the deceased, Sri Vishnu Talukdar, accused 1, armed with a formidable weapon, a solid iron rod approximately 4 feet 4 inches in length, initiated a vicious assault. His primary target was his elder brother, the deceased Sri Vishnu Talukdar. With lethal intent, accused 1 struck Sri Vishnu Talukdar on the head, causing a catastrophic injury. As the deceased 16-year-old son Sri Devasis Talukdar courageously attempted to intervene and protect his father, accused 1 turned his fury upon him, striking the body on the head with the same iron rod, inflicting a grievous one. While accused 1 carrying out his deadly assault, accused 2 Srimati Zonali Talukdar actively participated in the criminal act. Eyewitnesses' accounts establishes that she assaulted complainant Srimati Pratima Talukdar with a wooden stake, thereby ensuring that no one could effectively aid the primary victims. The violence, commotion, and the terrified screams of the victim's family dispersed the night's silence, altering the neighbors who rushed to the scene. They arrived to a horrific sight. Both Sri Vishnu Talukdar, Sri Devasis Talukdar were prostrate and bleeding profusely from severe head injuries. With the help of these neighbors, the victims were rushed for medical aid. However, the injury to Sri Vishnu Talukdar was too severe. After being referred from a local facility, he was admitted in a critical state to Signas Hospital in Kamalpur, where despite medical efforts, he succumbed to his injuries. He was formally declared dead at 6:30 hours on June 15, 2025. His son Sri Devasis Talukdar survived the attack but required 12 stitches to close the deep wound on his head. Hence the case, Lordship. Lordship, it is not a murder case, Lordship, as mentioned in the searches. Lordship, it is an accidental death, Lordship, by fight between two brothers regarding their ancestral property dispute. Lordship, no independent eyewitness is present in the search sheet except the witness of deceased wife, son and daughter, Lordship. Lordship, kindly go to the page number 33, Lordship. Lordship, last pair, you see, Lordship, Pratima Talukdar is the deceased wife, Lordship, Devasis Talukdar, deceased son, and Naina Talukdar, and deceased, she is deceased daughter, Lordship. These 3 years are the eyewitnesses, Lordship. Lordship, moreover, the weapon which was seized, Lordship, was not sent to the forensic lab only by simple reason, Lordship, that on the date of crime, there was a heavy rainfall and marks on the weapon may be washed off. Lordship, marks on the weapons present or not can only be decided by the forensic authority, Lordship. Lordship, I want to read the relevant portion of the search sheet, Lordship. Lordship, kindly go to the page number 33, Lordship. Second para, Lordship.
Yes, sir.
The murder weapon, the iron rod, was a key piece of material evidence. Acting on the information provided by Caesar witnesses, the investigating team recovered the rod from a garbage pile within the accused premises, where it had been concealed in an attempt to destroy evidence. The weapon was seized under a proper Caesar memo on June 16, 2025. Due to heavy rainfall on the day of crime, no stains or marks were found on the weapon. Hence, it was simply preserved without being sent to the FSL, Lordship. Lordship, I am in judicial custody for more than 125, Lordship. Lordship, I have a minor sick girl, Lordship. Lordship, my wife is also under medical supervision, Lordship. Lordship, I have submitted the medical prescription regarding their illness, Lordship. Lordship, kindly go to the page number 44 and 50, Lordship, Annexure 6 and 7, Lordship. Lordship, I have submitted the medical prescription, Lordship.
44?
And 50, Lordship. Lordship, I am the only bail runner of my family, Lordship. Lordship, co-accused of this case, who is my wife, Lordship.
Okay, the only two accused.
Yes, yes. My wife already released on bail by your court, Lordship.
You and your wife, only two accused.
Yes, Lordship.
Are you in a position to say whether what is the status of trial? Has it?
It wasn't charged. It isn't charged, Lordship.
First is not yet started.
Not.
Who Junali Talukdar? Wife.
Wife. I have submitted the previous bail order, Lordship. Annexure 11, Lordship. Annexure 11, page number 63, Lordship.
I see. Thank you. See. Yes, what do you
May
say?
I please, my lord, my prayer before Lordship, at this stage, my lord, scan copy of my lord PCR may be called for. And regarding the, my lord, I would like to, my lord, point out, my lord, page 35, my lord. Here there are 3 eyewitnesses, my lord. Page 35. Case of brutally murdered, my lord, deceased, my lord. Second paragraph, my lord, their accounts recorded promptly after the incident are remarkably consistent and mutually reinforcing on every crucial detail. All 3 witnesses unequivocally identify A1 Hemant Talukdar as the primary aggressor who wielded the iron rod. They each describe how A1 and A2 trespassed into their courtyard and thereafter, my lord, initiated the attack. And thereafter, my lord, his confessional statement.
You'll need
Lordship, no independent eyewitness is
Was-
present, Lordship.
Yes, my lord,
copy
independent.
of CD. His diary.
Yes,
His diary necessary because he has already annexed the charge sheet.
and yes, my lord.
Charge
otherwise-
sheet we can use this only.
my lord, present a status report, my lord, regarding the present status report of the case.
Okay. Third, Winston.
Mr. Rituras Patel, Lordship.
Call for the case diary of Nalbari case number 202 of 2025 under section so and so. Present accused was arrested on 19/6/2025. The allegation in the FIR. Let me submit. Stop. Certified copy of the charge sheet has been annexed and the learned counsel has taken the court to the relevant portions thereof.
Lordship, kindly fix a sorted.
Learned additional PP, I'll try. Learned additional PP submits that. The scanned case diary may be procured. Stop. Along with status report. Call for scanned copy of the the case diary, charge sheet. And as well as depositions if any. Stop. The learned court below will also send a brief status report regarding the stage of the trial and as to whether witnesses have been examined. And if so, how many? How many out of the, how many witnesses were listed in the charge sheet? What I think. 12, lot of witnesses. Out of the listed, out of the 34 listed witnesses. 34 listed witnesses. Right. This will take time, trial. Anyway, list the matter on 311.
311.
3 or 411. Now you you want to suggest something else?
711.
If it's not late for him, I can, no problem.
7-11.
6 or 7? 7-11? Okay, 7-11.
Obliged, Lordship.
May I please your lordship? Lordship, regular bail application, lordship, and I was arrested on 38, lordship. Today is 56 days. And FIR is at page, lordship, 8. Allegation is that, lordship, the informant along with another one were riding in a motorcycle, lordship. And accused shot at them. But the informant had not get any injury, lordship. The pillion rider got injury, lordship. And sections are, lordship, 118 to 10961, read with section 25(1)(a) and 27 of Arms Act, lordship. Lordship, today is 56 days, lordship.
We'll fix it accordingly, but the diary will have to be seen, right?
Yes, lordship.
Your good name, please?
Z Deka.
Z Deka, Learned Counsel. Call for the, is the idea of Romeo PS case number 199 of conclusion. Accused was arrested on 38,035. The Learned Counsel submits that he has completed 56 days in custody already. List the matter on.
That's it.
He wants to fix it on 611.
This will be 90 day, I think. This will
90 days, no?
90 days, because 307 will.
307,
Any,
1411.
you want 611?
611, lordship. Obliged.
May please, lordship, the regular bail application, lordship, the FIR page, lordship, 9, lordship. I am not named FIR, lordship, the accused person. Lordship, I read I, Anjit Datta, husband of the provider word Nishamuni Deka residing at Vishnupad, Brahmara, wish to file a formal complaint regarding the theft case and that occurred on the premises.
We have to see the forwarding report and why was he arrested?
Lordship, ground of arrest, lordship, page 15, lordship. I am the labor, Delius labor, the escape material shop, lordship. Lordship, ground of arrest, as per the information of reliable sources, the below noted accused serial number 1 Rizul Ali was apprehended and he confessed that he stole articles of the instant case and sold it one scrapyard of Fulsan located at Rajiv Gandhi Road, Betkusi. During search of the lead and shown the accused serial number 1 stolen article brass lamp stand is recovered from the scrapyard which was received and concealed by the accused number, the present petitioner, accused number 2. And the Delius labor, the lordship, the page 22, Caesar, 21, lordship, type copy, Caesar list, lordship. I am the employee, lordship, I am the Delius labor, lordship.
Rizul Ali.
No, Rizul Ali is the accused, main accused, lordship. I am the Jabbar, Abdul Jabbar. No allegation against me, lordship.
He may or may not be involved, depends.
Yes,
Has to be seen.
as per the grounds of
When can we see, when can we get it? Gorsuk PS case number, or case diary of Gorsuk PS case number 282 of 2025. Under so and so section. The accused was arrested on 11/10/2025. He is stated to be a daily labor and perused the FIR as well as the forwarding report. This is the matter on.
On 29/10, ma'am.
That will be perfect.
28 Lordship, 28 I am is not available. 28 Lordship.
28/10, yes.
Give the-
May please your lordship, lordship, for the time being, lordship, this is coming. For the time being, lordship. Lordship.
May I please, your lordship? Lordship, allegation is under section 319 subsection 2, 316 subsection 2,
Yeah.
308 subsection 2, and 3 subsection 5. Lordship will find the FIR, the translated copy at page 9, Lordship. May I read? Most respectfully, I beg to state that I am a self-employed resident of the below mentioned address. The below named accused number 2, that is Nilomani Nath, is in my acquaintance. The accused number 2 introduced me to the accused number 1, that is Champak Kumar Bora, who is the petitioner, Lordship, as an officer of the railway department, and the two accused met about 40 people whom I knew at my house and promised to give them jobs in the railway department. Accordingly, those persons collected the cash and handed over to me. The two accused took the cash from my house in the presence of the said persons. The accused number 1 took rupees 50 lakhs from me, and the accused number 2 rupees 30 lakh 50,000 from me. However, as they could not give the jobs, I asked them to return the money back. When the undersigned accused persons sought time, saying that they would return the money, they are currently threatening to shoot me if I ask the accused persons to return the money. I am currently in danger of my life. The accused have deceived me and taken a total of rupees 80 lakh 50,000 from me. There are videos of accused taking money from me. Now, Lordship, this is a clear case where this FIR has been lodged by the informant only to save his own skin, Lordship. I'm telling this because, Lordship, the informant himself introduced himself as a railway officer. It was not the petitioner, actually, Lordship, and he told that he would give jobs to those people as he was a railway officer. And so, as clearly stated in the FIR itself, that the 40 people were known to the informant, and those people handed over the money to the informant himself, Lordship. And when the informant was unable to give the jobs, Lordship, the people who gave the money pressurized the informant, and in this way, very tactfully, the informant has implicated the petitioner, Lordship, because there was some misunderstanding and the relations turned bitter between the petitioner and the informant, wherein the petitioner took this step to save his own skin, Lordship. This is the case, Lordship. As of today, Lordship, 21 days behind bar.
Otherwise, yes, that month from the FIR, it reflects that from in the house of the residence of the informant, those, my lord, dealings where it takes place. But anyway, my lord, case diary is necessary considering the, my lord, allegations, my lord, regarding the involvement of the present accused, my lord. As per forwarding report, my lord, the forwarded accused person has cited many people.
Basically, one of the things which emerged from your contention is that he himself might be involved. Something of that.
Yes, Lordship, because he introduced himself as the railway officer,
There is-
Lordship.
Sometimes
Forwarding report is at page 15, my lord.
yes. Nagaon PS case 762 of 20. Arrested on 3/10. Learned Counsel has taken the court through the FIR. I have also perused the forwarding report. Is the matter on
On my
311?
310.
311?
Yes, Lordship. Much obliged.
May I please, your lordship. Lordship, this is regular bail application, lordship. FIR will find page number, lordship, 11, lordship. And operating person, lordship, and kindly come to page number 13.
49.
Very small FIR, lordship. And apparently, I have gone through the FIR, lordship. There is nothing involvement of the petitioner. Only one line is, lordship. May I read, lordship? Page number 13, operating person, lordship. May I read, lordship? I would like to report it that on 23/9/2025, information had been received from one police control room that some suspected nationals are detained by Bobby Laws Ulubari as they could not produce any valid documents and their identity. Accordingly, as directed and so and so, and Polton Bazar PS, we are detained to inquire into a matter and bidding the suspected nationals at Polton Bazar PS for verification. During the verification, it is found that the apprehended persons, namely Abdullah Farji and so and Zakir Khan and MD Milon, and suspected to be Bangladeshi national, and they came through Meghalaya border and traveling to Bangalore for searching work with the help of the local person, namely Raju Sheikh and so, West Bengal, without valid passport and travel documents. Accordingly, he was apprehended and found involved in the deportation and suspected nationals from Bangladesh for his wrongful financial gain. Only that much, Lordship, and is it
Thereafter,
possible,
during
Lordship?
preliminary inquiry, my lord.
And during the
Last question.
preliminary inquiry, Lordship, the apprehended person, namely Raju Sheikh, the petitioner, Lordship, and had criminal conspiracy and secretly deportation of the aforesaid suspected nationals from Bangladeshi with the valid documents for his personal monetary gain, Lordship. So, my lord, the present petitioner is a head of the Mason, Lordship, and he is working in the Guwahati area, Lordship, since long back.
Head of?
Mason, Lordship. And Lordship, and he engaged, there are many laborer in his working site, Lordship. I am very specifically mentioned in my petition in para number 4. And so, my lord, and how can Lordship and the allegation made, Lordship, it is a total contradictory because India is also deploying the smart fencing technologies, and which Bangladeshi could not approach the fencing in border areas, and to also present logistical challenges to completing the fencing project and so and so. And CCTV cameras and motion detectors and combat illegal activities has been installed. Moreover, both the countries agreed to join efforts to combat human trafficking. So, my lord, he is the Mason, Lordship. Is it possible, and he will be beating some person from Bangladesh, and again he will be deport them from India? Is it possible? And now, to Lordship, and today more than 1 month in custody, Lordship, and very poor person. And otherwise, Lordship, and there is the heavy security in the border area. And so, my lord, only this much, and the allegation, Lordship. Otherwise, he is an Indian citizen from Bengal. And his all documents is verified, Lordship.
These are serious offenses,
And
my lord,
all
offense
the-
against national
and-
security also, my lord.
Border area, Lordship, and one court is well aware, and is it possible one person can be beating?
No, I mean, but, smart fencing,
Lordship.
it's electronic.
Electronic, Lordship, and there is the CC camera also, and combatant motion detectors, everything is
They're
detected.
taking a lot of steps nowadays, anyway. I call for the Polton Bazar PS case number 295. The accused was arrested on 24/9/2025. Mr. Hawk, learned counsel, admits that petitioner denies the allegations against him of being involved in movement of illegal movements of persons from Bangladesh in an illegal manner. List the matter on.
My lord, 12/11, my lord.
12/11.
12/11.
Lordship, can be Lordship is Polton Bazar, and my lord, one submission, Lordship, and this section is here, Lordship, and
Foreigner section.
Lordship, section 12, subsection 2 Passport Act, Lordship, and when one person came with a Lordship passport, and after expiring the visa period, and subsequently Lordship, and he will be, and this section is not come.
14C can be applicable.
And that is also
Maybe
not,
time of a C.
not come, Lordship.
Let's see, a little earlier. than
Oh,
that.
yeah, on 7/11, my lord, 7/11.
6, Lordship, can be 6, Lordship.
6/11.
Obliged, Lordship, obliged,
See your calendar also, huh? Whatever.
obliged, Lordship.
Yes.
Lord, it's a allegation is, my lord, manufacturing of Sulai. Lord, the sections are 112, 61, 35 of BNS, and my lord, section 53(1)(a), 54, 63 of Assam Excise Act. Now, my lord, accused was arrested on 14/10/2025. Your lordship will find the FIR at page, my lord, 8, annexure 1.
Yes.
My lord will see, this FIR was registered by the CDSP himself while conducting a search. He made a search, my lord, in two places. From first place of occurrence, my lord, that place is the residence of accused number 1, 2, 3, and 4, that your lordship will get the name of the accused persons at page 8. Page 8, A1, A2, A3, A4.
The present accused is.
Present accused is
Bhuvan
A6 Bhuvan Gogoi. And has your lordship?
Yes.
Yes. My lord, this Bhuvan Gogoi's residence is place of occurrence number 2. Now, what has been found in place of occurrence number 2, your lordship will see at page 10. Page 10. Last paragraph.
Then
Ah.
after the seizure.
After the seizure process at place of occurrence number 1 was finished, we also got information that PO2 also there is a Sulai Ghati and a manufacturing unit to manufacture Sulai. Since PO2 was very close to PO1, we decided to immediately conduct the search with the existing witness. E-Sakyo video was turned on, right, so and so. It was found that since the raid at PO1 was going on, A5 and A6 fled away, locking their household premises. Also, they destroyed the Sulai Bhati and set off the fire and had thrown the Sulai as can be seen in the video. But still the premises of A5, it should be A6, A5 and A6. Search was conducted and near the tea garden area of A5 and A6, we found two plastic drums filled with a mixture of lali gur used to manufacture Sulai, approximately 200 liters each. That was destroyed on site, as can be seen in the video.
Yes, I've seen the last
No,
part
that,
also.
that is the only.
He was arrested. When was he arrested?
He was arrested on 14/10/2025.
PS case number 155/2025. Accused was arrested on 14/10/2025. Here is the FIR with the dated
Lord, FIR is dated
with the assistance of the learned
25/9.
counsel, petitioner. FIR dated 25/9/2025. This is the matter on
My lord. 311.
I'm obliged.
Tita board. Film.
Your lordship. I take your lordship, 483 application, my lord. They were arrested, my lord, on,
28/9.
yes, arrested on 24/10. And now, no, I'm sorry,
28/9.
28/9, my lord, 28/9.
Okay.
Now, my lord, FIR is at page 16. The entire allegation is that one Manojyoti Das was given the hand over his car on rent. My lord, he has sold out it in Manipur, my lord. And other co-accused are, which is with their known person, my lord. In this case, 2 persons has already been granted bail, my lord. One order I have annexed by Honorable High Court and another by the court the below, my lord. The page 34. And that is the order of the bail. So, my lord, 406 and 420 equally are not applicable, my lord. There is a judgment of our own High Court acting in the apex court also in this case, my lord. This is the court below, my lord. And the High Court has also granted bail, another co-accused, page 34. I have annexed both the order, my lord. So, my lord, since 28/9, I am here, almost nearing a month, my lord. I may be allowed to go on bail, my lord. I am 27 days today, my lord. To my humble comment,
He has the informant has a higher
Higher.
Your lordship may kindly come to page 20, my lord, that is grounds of arrest.
Yeah, 20.
Page 20, my lord, grounds of arrest, ground number 3, my lord. Why, my lord, the present?
Deep Roy Harshan. Anyway, let us see what. Just a minute.
Yes, madam, deep.
I'm just seeing from the beginning, this wording.
My officers, I know Assamese and Manipuri language both, and I have convinced the Manipuri guy.
Ground number is mentioning.
Ground number 3. And your lordship may kindly peruse page 20, second paragraph also, my lord, during investigation.
Page?
Same, my lord, same page, my lord, above, that is, my lord, second paragraph during
Yes,
the,
sir. This
during
I
the
will-
course of investigation.
It will be necessary. The dispute, yes, you can get third essay basis one.
My lord, I have.
Yeah.
How I was tortured, I have annexed, my lord. There is a findings of the learned judicial magistrate, my lord. My lord, page 31.
Page 31.
Yes.
You should take the matter.
But how I was tortured, my lord. Matter has been
Accountability
sent to
Commission.
Human Rights Commission.
Take it to Human Rights Commission, Police Accountability Commission.
Yes, madam.
Custodial violence will not be tolerated, whatever it is. You
Yes.
have to investigate within the corners of law,
Yes.
right?
And that page also, my lord, page 33, last portion, fix 1310, regarding that allegation, my lord, 131025 for medical report.
We can
But
report and
regarding-
reply should be
Uh,
sought for.
For
A reply
medical
should be
report.
sought for from the IO.
Yes, but in the present petition, there is no mention about the
Anyway.
report.
No.
He had to be admitted into the hospital for torture has been committed after him.
Call for the case diary of Dispur PS 639 of 25. The 766 section. The accused was arrested on 28/9/2025. Here is the FIR as well as the forwarding report. Full stop. It is submitted by the learned counsel, Mr. Biswas, that after his arrest, the accused was subjected to custodial violence, for which the learned magistrate has called for a medical report soon. The said aspect may be taken to its logical conclusion as per the procedure in law by the learned magistrate. This is the matter on
On 411, my lord.
411.
May I please, your lordship, my lord? It's third application, my lord. The new 326 and 307 is there, my lord. Life is there, so 90-day period offense, my lord. Today is 79 days as on date, my lord. May I pray for the up-to-date case diary, my lord, any date, my lord? On the earlier occasion, it was rejected because the investigation was still not complete, my lord.
Call for the case diary.
Yes.
And Mahajan, learned counsel, who fairly submits that this is two earlier bail petitions were rejected by this court, and praise for calling for the updated case diary. updated case diary of Baushistov PS case number 395 of 25 may be called for, may be procured. The accused was arrested on 7/8/2025. List on
411 or 611 or 411?
complete period.
On my lord,
6 he may be, he may complete the
on
period.
third, it will be 90 days, my lord.
Huh?
On 3/11, it will be 90 days.
Then 311 only.
4/11.
On 4/11, it will be 91 days.
No, no, you will get 4/11, you can
Right.
be granted bail if the CD doesn't come.
Obligation.
It will be
61 here, my lord, lordship has sought for instruction regarding investigation, my lord.
My lord, as per my verbal instruction, my lord, see, in this case, charge sheet not yet submitted, my lord. IO is ready to provide the case diary, my lord.
Here, my lord,
61, right?
61.
Okay, he has completed statutory period.
Earlier.
yes, my
TDO
lord, today is 60 days, my lord. The offences which are non-bailable are, my lord, 75 and 69, my lord. 75 is extended to 5 years, my lord, and 69 is extended to 10 years, my lord.
Today, it will be merit bail, because his case diary has been received.
No, my lord, case
Okay.
diary. Case diary not called for earlier, my lord. Only regarding instruction.
Today is their last chance to file the, this thing. If I give, if bail order is made today, it will not be default bail, it will be general bail. Tomorrow, if it is made, it will be default bail, but no point waiting.
Yes.
I can
yes,
dispose it.
this-
483 N Mahajan, Learned Counsel, additional PP, P Botakut. 483 bail application under section for the All Women Police Station PS case number 74 of 25. The allegation was about, what was the allegation?
FIR is at page 15, my lord.
15.
The foreign report is at page 30, my lord. The brief facts is there in concise manner, my lord. Page 30, my lord.
Long affair, my lord, from.
Page 30, it is in short form in the foreign report, my lord. Brief facts of the case on 26/8/25, the complainant so-and-so lodged an FIR at All Women Police Station case against the accused, my lord. Telling that the complainant,
The statutory period is 60 days, so
60.
we have to check
60 days, my lord.
60.
all offences.
All are bailable except, my lord, section 74 and 69, my lord.
My lord, your lordship may kindly fix it at to whether any new section added. I will only otherwise see the, if added, my lord, then I will get the instruction. At two.
Okay, you take an instruction and also ask him regarding the
Yeah.
investigation.
Because CD, my lord, as per my instruction.
Let us see the forwarding. You wanted to show me the forwarding page.
Page 30, my lord. Only the brief facts, lordship wanted to see the
Brief
brief
fact.
facts, my lord.
That will help.
Yes, 30. 69 was written subsequently, my lord. That is the new section added, my lord.
The 60 days. You take the 60 days. You take 60 days.
Allegations are there. Anyway, you take the instruction.
Yes, at two.
In any case, tomorrow is holiday and 60 days over.
Tomorrow and it will be.
At two, at two.
You take the instruction.
Ma'am, have any?
May I please, my lord? My lord, this is 483 bail application arrested on, my lord, 18/6/2025. My lord, charge sheet also submitted, my lord, FIR is at page 10, my lord. May I read, my lord? Most respectfully submitted that I, Srimati so-and-so, Village so-and-so, Margareta Makum, District Tinsukia, Assam, on 15/6/2005, Sunday at around 12 noon, my daughter Srimati so-and-so, along with her 4 friends, went for shopping. At Lekhapani Bazaar, they met a resident of Lekhapani, Balijan Gaon, namely Suraj Koiri. He is the petitioner, my lord. After her 2 friends stopped at Lekhapani, Suraj took the 2 friends and my daughter to Lido. At Lido, as it will be late for stitching clothes, Suraj Koiri, in a coaxing manner, took all 3 to Digboi. At Digboi, after eating and roaming in the park, in order to come back to Lido Tea Estate, they returned back. Thereafter, near Lido bypass, one easily step out of the car, but another one jumps out of the car. Meanwhile, my daughter so-and-so could not come out of the car as the doors were being locked. My daughter so-and-so was made to consume something similar to medicine and took her to Digboi in the evening. Then after keeping the night at a resort named Speed Villa, situated at Digboi, committed rape and in the morning drop her in.
Well, my lord, now this is my lord transit anticipatory bail. Already, my lord, the petitioner is in interim.
For a long time.
Since
Yeah.
long time. So my prayer before lordship, my lord. Otherwise,
Disposed of,
yes,
given
yes.
15 days.
Otherwise, because other offense is serious, my lord. Taking advantage of that, my lord.
That is the orders which were passed by some of the coordinate banks. Actually, that is an easy option.
Yes.
That the first day only you give the person some time
Yes.
and then he goes and approaches the jurisdiction,
Yes.
right?
Yes.
But since one of the conditions is that, the first condition is that notice has to be issued
Yes.
to the jurisdictional IO. And, IO could be served, right? IO could be served. The
Yes, Lordship.
prosecutor could not be served.
On
I
this
hope this-
order, yes, Lordship, but on the order, there was
That
for PP, Lordship.
it will be.
Yes, yes. No, IO has been served earlier.
Yes.
Yeah, IO will not be very difficult, but public prosecutor, we don't know,
Yes.
different states have systems that might be different, whom to contact. Actually, some, maybe some SOP will have to be
I
prepared for
appeared
this kind of
before,
IO also.
yes.
Your lordship may kindly, that is the prior injurious, those
Yes.
points your lordship has already. Your lordship may kindly,
First condition,
last portion, my lord, I am little bit confused. In case your lordship without even last portion, my lord. What can even instead of, my lord? For a fixed period, my lord.
no, this can be applied.
Yes, this can be only for a fixed period.
So even without notice, this can
Without,
be applied.
without notice also.
But for
Otherwise, otherwise, in case of granting, my lord, interim on the first day, my lord, on the pretext of providing.
He
my
may
lord,
be may get
then
delayed.
Delayed, otherwise offense is serious, my lord, there is a cyber offense. my
Sometimes
lord.
it may get delayed, that's the
Yes,
thing.
yes.
So we can apply this.
Yes, only
So
for a
probably
fixed
apply
period within
this
that.
only the coordinate benches.
Yes,
have given.
yes.
So in that case, what happens to that notice, directly?
Notice, my lord, in that case, question of notice will
Parallel.
not come, my lord. Then it is his, my lord, period. Then he may, within that period, he may approach before that.
That's the easiest
completion.
option actually.
Yes, ma'am.
Interim bail, actually for us, though it is said interim bail, but for us, the matter will be disposed of.
Yes, yes, ma'am, this.
Anyway, we do that. 15 days, right? Then you can straight away go and approach. It will be Madras High Court. No, Calcutta. High Court. Or the jurisdictional sessions court. They do. They promote. Deep political. So I got order to follow, second, third paragraph is same. Fourth paragraph উঠাই দিলে হ'ল কিন্তু relevant paragraph নহয় individuals of the liberty of the individuals of the Eleven nine orders in 11 9. As reflected in order dated 25/9/2025. The petitioner had personally appeared before the jurisdictional IO in West Bengal on 23/9/2025. However, the petitioner has not been able to notice the jurisdictional public prosecutor as on date. Full stop. Considering the fact that it may not be fair to keep the matter pending, I deem it fit to dispose of the same. The petitioner is granted transit anticipatory bail for a further period of 2 weeks from today. to enable him to seek bail from the jurisdictional court. Jurisdictional court. Stop. The petition stands allowed and disposed of on the aforesaid terms. 2 weeks time till, it will be better to fix a date, I think. No? What will be the date after 2 weeks?
After 2 weeks, my lord,
24,
10 or 11,
31. 7.
7.
Obliged.
2 weeks time, till 7/11/2020. That will be best. This is in the last paragraph no, of this
Yes,
summary. Good, you pointed it out. Okay. You can keep it with you.
Yes.
We'll leave it with. This is in para 94 actually.
May I please, Your Lordship? The office note, Your Lordship, I have seen. Notice has not been served.
This is also, my lord, same.
Same, this is also.
We can do, pass a similar order.
Yes,
Yes,
similar.
He has been able to. Yeah, you've sent notices. Could you send notice?
Yes, yes,
But not served.
not served.
Not served.
I have seen the office note, Your Lordship.
Yes, Do judgment of organization. Office note says. Judgment or copy. I'll need it again. I should, you can make a copy. You do last order, 1310 order, first 2, 3. First 2, 3. Again. The petitioner was granted interim transit anticipatory bail on 13/10/2025. The learned additional PP has drawn my attention to para 94 of the leading case on the subject dash Priya Indoria versus State of Karnataka, 2024, 4 SCC 749. Mommy Ulaila, no? Para 94 may be reproduced herein below. It is submitted by Mr. Khan, Learned Counsel, submits that the petitioner has not been able to serve notice to the jurisdictional IO and prosecutor. The given facts and circumstances, I do not deem it necessary to keep the bail petition pending. Accordingly, the petitioner is granted a transit anticipatory bail for a further period of 2 weeks till 7/11/2025, during which he is at liberty to approach the jurisdictional court within bracket S courts for the anticipatory bail in a regular manner. The petition, it will be best. Yes.
Lordship, the time limit, Your Lordship,
2 weeks.
it kindly 3 weeks, Your Lordship.
Let it be because enough time, just. You want 3 weeks time?
Yeah.
14/11, 3 weeks time, 3 weeks time, 14/11.
Your Lordship, allegation is under section 3153, 296 BNS, read with section 912 of Assam witch hunting. Lordship, similar case as item number 2. Lordship,
Same case.
same case, but we have not been arrested. We are for paying for anticipatory bail. Same I am for the 7 accused, except for the accused and page number 13, the name of the accused persons have been reflected, except for accused number 4 and 5, I'm appealing for other accused. Lordship, the FIR is also the same. I'm kindly reading out the relevant portion.
So I remember.
Lordship, may I submit, Lordship?
Mm.
As per Assam Witch Hunting Prohibition, Prevention and Protection Act,
2015.
Section 30 says, Lordship, this is not, anticipatory bail is not applicable.
Not 2020.
That is,
Oh, I didn't know this. No. Thank you for pointing it out. Can't help it. Like, actually, personally speaking, it's not a very good, it may not be good policy to do away with anticipatory because there may be so many, real life situations where a person may not be involved and he may apprehend arrest.
yes.
So that's, UP, all the petitions used to come on 482 earlier. So I think, I don't know, it has been, it is still there in UP or I'm not sure. Like SC, ST Act.
STS,
You know, the 18A removed, but yeah, the Honorable Supreme Court had to lay down a window that if there is no prima facie case, even in that case, the person will have no remedy or what. He should have a remedy.
Yes,
right?
Lord.
You should have a remedy.
Yes.
So either, even if you remove it, either there should be a proviso.
Yes, otherwise.
Or it is better to keep the option open.
Yes.
But the court will decide the assistance of the counsels, two counsels and the prosecutors.
Yes.
But anyway, since this is the law, we can't help it.
Yes.
The instant. But the remedy should be available, I think.
Yes.
Personally, I feel. Some stringent laws, this is being done,
Yes.
but that like at least window should be kept open.
For the
But
ends
that
of
is the
justice.
judicial interpretation of 18A. Judicial interpretation. 482. Your good name? Mazumdar.
Tanmay Majumdar, T Majumdar.
T. Mazumdar, Learned Counsel and SH Pora. 482 BNSS application seeking anticipatory bail for petitioners 12,000 under section. So the Learned Additional PP has drawn attention of the court to section 30 of the Witch Hunting Act, Assam Witch Hunting Act, which reads as follows. Section 2. Section 2. We'll find it in the net, I think. No? So thus it is clear that the section 30 of the act statutorily bars an anticipatory bail with regard to offences under the act. So, no exception to the same has been provided in the act. Further, no decision of this court making out any exception to the statutory bar has also come to notice. Therefore, there is no other option but to dismiss this petition, and accordingly it is dismissed and disposed of as not maintainable.
Yes, obliged.
And we'll be able to take out from internet.
Not.
We'll be able to take out. Otherwise, we'll take it from. I did not know this actually. It's quite stringent. Isn't it? Yeah, and there's another side aspect of it, but whether they will be able to do that or not is a very big question.
Not sure.
Actually, in laws, in laws where anticipatory bail has been removed, the
Yes.
police is expected to be even more careful
Yes, Lord.
in wanting to arrest someone. But whether you can, in practice, whether that will be possible or not, because the person does not have a remedy.
Yes, there has to be some remedy.
Yeah, they have to be even more careful in not making unnecessary arrests. But that is again only in theory. Disposed of.
May it please your lordship. My lord, this application is filed against the PRC case. The petitioners are shown as my lord absconded in the charge sheet. My lord, petitioners are willing to cooperate with the proceeding, my lord, and claim they're paying for my lord similar The benefit as date of order dated, my lord, 25/9/2025, page, my lord, 39.
Page.
39, 36, 39. Similar orders.
Same FIR.
My lord, same affair.
Dispose of on this.
Your lordship, scan copy was not.
Can
there.
go- Similar order is there.
Yes,
You can dispose it of. Have you annexed the charge sheet?
Yes, your lordship. Petitioners are declared as, my lord, absconder. Page, my lord, charge sheet, starting
Better to
from, my
see it
lord,
once, right?
page 19.
For my satisfaction. I've got it. Ivan. He is Joinel.
Yes, your lord. All are
And then
family
I'm-
members, my lord.
And two others, lordship.
Joinel.
3 persons before adoption. Joinal, Jeffrey
Three
Hussain,
were searched. Three
Jeffrey
persons
Hussain
searched.
and Nur Alam.
Joinel, huh? Noor Abedin.
Zakir is page 23 in the charge sheet. Petition, my lord, and Ainal already granted bail, then Nur Abdin, page 25. And Zoinal, page 26, my lord. All are absconder.
Jeffrey bail conspiracy.
আমার similar order
I know.
is like, no? I will get on my place.
Zakir, Zoinal
I will
bail,
now
yes.
change for you, then I'll see what can we. That is summation kal thayo. To page 39. I ordered it at 25/9/25, AB 9/7 of 27. It is submitted by the learned counsel that that the petitioner is willing to appear before the learned court below and cooperate with the trial, and that he may be given a chance to do so. Full stop. It is also submitted that co-accused Ainal Haq was granted similar relief by this court in AB 957 of 25. Stop. Peruse the annexed copy. As an peruse the annexed copy. Full stop. Allowed and disposed of. Other mining part.
Highly obliged, your lordship.
Go ahead.
So this is an application under section 482. Well, we'll find the FIR is at page 19. The allegations are basically non-payment of the PF dues of the employees by the employer of the Ghurajan Tea Estate.
It's a non-bailable offense. That's
My lord, it is, my lord, only 1 year, my lord, under the act, some
Tea
plantation act.
plantations provident fund.
But here, my lord, this has been registered under section 420, 406 and 409. That is apparently, my lord, because there's a special act, so that should prevail. So nonetheless, this has been registered. Now, so far as petitioner is concerned, my lord, he is the, my lord, Karta of a HUF, namely JN Sons and others. That owns the Ghurajan Tea Estate, which is the tea estate in question. And he is about, my lord, 85 years old and resides at, my lord, Kolkata. Also, my lord, old age ailments are there. Now, in 2019, this property was on an agreement given to an MPI Associates, who basically runs, and it, my lord, took the, my lord, responsibility of payment of all dues and etc.
And failed to do so.
Lordship, my lord. So therefore, primarily, my lord, it is the MPI, my lord, which is, my lord, and otherwise also, my lord, these are all, my lord, documentary things, my lord. Okay. In fact, my lord, the one of the, this, member of the HUF, he has been granted bail by the session court, but because of the difficulty of the petitioner going to Dibrugarh, he is approaching this court.
Concurrent jurisdiction. Get the diary, but some will, you can give interim then. 482. Sape Khati, PS case number. Sapekati is in Golaghat.
Toraido, he was Sipsagar.
Toraido.
Sapekati PS case number 40/2024. Under section 12 of Mass. The gist of the allegations in the FIR dated 19/10/2024 lodged by Dulen Sonowal is that the employers of Horajan Tea Estate in the district of Soraido Assam failed to deposit the provident fund contributions deducted from the wages of the workers along with their matching contribution. Full stop. Amounting to more than rupees 1.27 crores for the indicated periods. Full stop. It is submitted by the learned counsel, Mr. Saikia, that the present petition, he is the, what did I just missed that, he is the,
He's the Kota of one HUF,
Karta.
Karta,
HUF.
HUF, namely, JN Sons and others.
He is the Karta of HUF name,
JN Sarma and others,
CN Sharma and others, and
which owns the garden in question.
which owns the gardens, and the day-to-day management of the garden has been entrusted to
One
tea
M-
estate, to garden, tea estate, was entrusted to
One MPI Associates
one MPI Associates
on an agreement
on an agreement. and-
dated 9/4/2019.
agreement, and the said, so the said or for organization was supposed to deposit the EF amounts. It is also submitted that the petitioner is aged 85 years. Call for the case diary from the concerned police station. However, in the interim, in the event of so and so, 25,000 with one security. He'll cooperate with the investigation. Can he record his statement by VC? With the
Perhaps
IO?
that will be possible.
He'll cooperate with the investigation. Number two, he shall make himself available. He shall make himself available for examination by the IO. Stop. In this context, since the accused petitioner stated to be aged 85 years,
And
he's
also
at liberty to get his statement so recorded through electronic mode also.
Let it be on 20th
He
of
shall not,
November.
he shall, 20th,
11, yes.
Okay, list on 2011/2020. বহুত কেইটা হেৰিও আছে, মেনশ্যন আছে। Diary has been received?
Diary is not available.
Not received?
Not received. Lordship. Your Lordship, search sheet has been filed, Lordship. Nandita? Your Lordship, search sheet has been filed.
Charge sheet has been filed?
Yes.
First two paragraph. No, do not. I'll give the order. Last, I'll give the order. Dispose it of. 19/3/25. First two paragraphs. Two petitions.
36.
The allegation in the fire is that the accused persons came to her house in the absence of her husband, who was away in another state for work, and robbed her, tore her clothes, and also took some.
May appear before the trial court, also the trial court will decide in accordance with.
So this complaint was sent to the police for
Yes,
registration of case.
And subsequently registered a case, Lordship. Initially, both the victim and the complainant went to PS, Lordship. Then the mobile was seized and deleted the entire video and photo, Lordship. And after 25 days, filed this complaint case.
There's a backdrop to that, actually. There was some assurance, but that was not followed. Gary has come.
Yes, Lordship. Lordship, statement of witness, all the witness implicated him, and in his statement, Lordship, he confessed that he has made the videography, Lordship.
He was let off with an assurance. Then
Yes.
again, one day he found older videos in the phone from the police.
And subsequently filed this complaint after 25 days of the alleged incident.
Naturally, anybody will be concerned, girl, especially. Can I have a look at that?
Yes, Lordship.
18 years of student, Lordship, is a school going student, Lordship, studied in a class 12, Lordship.
Regular bail would have been different, but we don't know where to.
Young boy, Lordship,
Offer.
probably 18 years of.
As a result, I sustained injury at my upper torso, my legs, just right before my neck. I was discharged by the GMCH on 8th. I recorded my statement and on
Some,
10th.
during some eviction proceedings.
Yes, Your
Yes,
Lordship.
Lordship.
Yes, Your Lordship. And I'm on my deathbed, my lords. I saved, my life has been saved just by nanoseconds, my lords.
Please, 9.
FI is at page 17.
Page?
17.
Yes, I've read
Oh,
this. I think.
Yes, Your Lordship. So basically, my lords, what happened is on 12th, there was some eviction that happened at Gwalpara, my lords. On 17, my lords, the police forces, they tried to disconnect the village road to the main road. But at that point of time, there were few people from village, they went there. I was a daily wage worker, my lords. I was working just nearby the house in which I was, my job was to collect all the leftover and then, so I was out of curiosity, my lords, I was there. I went at that time, police shot me, my lords. And my lords, may kindly see the nature and the way I have been shot, my lords. I have been shot at the upper torso right before. I have the photograph as well, my lords.
He's now in hospital.
Discharged, my lords, 8th October, my lords. And I have also recorded my statement on 10th October. I'm not able to walk, my lords, at that stage.
The bullet grazed.
Yes, my yes, my lords. And it is behind my back. So it is not something that I was charging. It was something that I was turning back. That I realized that there is something that is happening. And it happened from quite a backside. So it's a fit case for granting me anticipatory bail, my lords. And otherwise, my lords, there are three anticipatory bail has been granted by the learned district and session judge, my lords. And one BA has been granted. And if you lordship will come to page 19, my lords, there are 4 people who were injured, my lords. My name feature it's there are 4 people. My name feature it's number 2, my lords, Kusumuddin. First, Sokoya Ali, he my lords, passed away. Yeah, look at his age. He's just 19, my lords. And 4th number, he has been granted bail by learned additional session judge. So I have recorded my statement, my lords.
Statement also recorded.
I have recorded my statement. I am ready to comply with whatever capacity the investigation wants, my lords. All of this is a matter of a trial court, my lords. And my lords, in no way, my lords, can it be considered that the violence was proportionate, my lords. Even if we assume that the FIR was, the moment that the police thought of shooting me at the upper torso, it was a decision that I have been punished, my lords, at that point of time. So, my lords, may I kindly consider, my lords, please consider my anticipatory bail, my lords. Whatever I have been, I have suffered enough.
There was a lot of clash. As many as 11 forest personnel were injured, and 9 policemen were also injured.
Yes, Lordship.
Anyway, I don't know what
Yes,
is it.
Lordship, 4 to 500 people, Lordship, were there, so it is not possible to, Lordship. Witnesses, as per the statement of witnesses, Lordship, বহুত মানুহে বিভিন্ন গাঁৱৰ পৰা আহি চৰকাৰী কামত বাধা প্ৰদান কৰি কাজিয়া কৰে. All the witnesses stated, Lordship, same thing.
Difficult to say out of so many people
Yes.
who's involved, who's not involved.
Yes, Lordship. Names are not mentioned here.
Any specific material against him?
No, Lordship. Some injury reports are there, it is simple with blunt object, Lordship.
Heard instant bail application filed under 482 BNS for Kosimuddin Sheikh in connection with Krishna PS case number 40 of 2025. Both sections are same. The FIR dated 18/7/2025 lodged by it was lodged by a police official, right?
Yes, sir.
Complainants. FIR dated so and so alleged that on 17/7/2025 in the morning, a team of police and forest officials led by the informant were engaged in disconnecting a road near the place of occurrence. And during this operation, a mob of 400-500 persons entered the area unlawfully and attacked the forest and police party with weapons, and as a result of which 11 forest personnel and 9 police personnel stated to have been injured. It is alleged that the incident created a volatile law and order situation. Several persons from the mob were also injured. The names of whom have been mentioned in the FIR, and it also includes the present Simuddin. It is submitted by the learned counsel that the statement of the petitioner has been recorded, and he took treatment in hospital due to bullet injury. A photograph is also placed before this court for perusal. The learned additional submits that the case diary has been received, and the investigation has confirmed the allegation that the police and forest party were attacked by a large mob involving many persons. Considering the nature of the matter, I do not deem it to be a fit case for grant of anticipatory bail. Accordingly, the petition stands rejected at this stage. Return back the case there. It may not be.
Only when
So these are more violence cases.
I have suffered violence.
And that's
I'm ready to.
He was also present there. Anyway.
Lordship, Mr. S. Nawaz is on his legs in another court. Yeah, at 2 p.m. if you permit. Yeah. Obliged, Lordship.
Yes, 483 application. Case diary was called for.
POXO was there.
Yes.
Notices.
Your Lordship, charge sheet has been filed.
Or also POXO, and subsequently when the
Yeah, issue reminder for the scanned case diary and charge sheet. That will do, no? Case diary and charge sheet.
Yes.
So we have to see 37, right?
Yes.
List on,
Lordship, as per the convenience of the court.
not, I do not know the calendar.
It has to come to
29
registry, Lordship.
29 will it come?
29. Although, Lordship,
First week of November.
more than
We can fix it, but it may not come. 29 day, but it may not come.
May not come, that's why.
May not come. 311,
311.
311.
obliged.
With case records and charge sheet and CD, Lordship.
Yeah, charge sheet and fix. Including FSL, if available.
FSL.
Obliged.
May I please, Lordship? This is substituted case. The petitioner Lordship is behind the bar for 101 days. POXO is there.
POXO is there.
My lord.
My lord, that grounds of arrest, my lord, 1, 2, 3, 4, my lord. Below that, my lord, the paragraph, my lord. Under the above facts and circumstances, he has been arrested and forwarded to the honorable court. The ground of arrest has been communicated to the accused person by serving arrest memo and notice under 47 BNSS, and also to his relative through WT message, my lord. My lord, that 48 notice, my lord, my family member did not receive it, my lord.
WT message may not be, anyway, may not be sufficient.
I have, with my friend, my lord, I have checked the records, my lord. It seems, my lord, the notice was sent to the concerned police station, my lord, but that was not served upon us.
Then we'll have to gather from the.
Yes, she has also gone
I
through.
have
my lord.
gone through, Lordship, so whether I can take a small, whether I can make a small prayer, so that if I get any instruction to that.
No, no, how can they, how, at
Whether
this
it is
point, my lord,
available or
it-
not,
Lord,
Lordship.
it is a charge sheet
Can we
case.
verify?
All documents have been given. Now how she can take instruction, my lord?
Let me say,
Be fair, my lord.
That
some-
is not there, Lordship. That is
It's
admitted.
not there.
Not
Whether
there.
it is available or not, can we take a,
After filing the charge sheet, well, how she can take the instruction from the concerned animal?
Instructions
we
can
can
be
call
taken
for the records.
on
also.
anything. That
From
is
where?
there. That is
On
not
the
a problem.
courts.
Court
Let me
record
see.
is there.
I'll also
Take it
have a
up on
look.
Miss Wilson, no?
The notice was sent by WT message or
WT
the,
message was sent.
notice,
That is-
notice was not sent at all.
Yes.
It was sent.
It was sent
Notice was sent.
to the
but
concerned police station.
Police
my lord.
station,
But it was not
WT
served.
message.
It was
but
not served.
It was not served upon. So
This is the WT.
yes.
Yes, my lord. But it was not served upon us. That is the only ground, my lord.
The reasons are okay. The
Yeah.
grounds are okay.
It's
Grounds
okay, my
are
lord,
okay.
but it was not served upon us.
That is what Lordship.
And one more, my lord, or one more submission, my lord, if your lordship pleases, my lord, may I
Yeah.
submit? My lord, page 36, my lord, of my petition, my lord.
So if it was served to the family member, then they would take an endorsement.
Yes.
It
So
would have
that's what-
come with the.
Yes.
That's what I'm.
That's what you wanted to take instruction.
And one more thing, my lord, page 36 of my petition, my lord, last page, my lord,
Take instruction, no issues, that is okay. Page 36.
page 36. my lord.
Today only you can ask.
Yeah.
My lord, This is the arrest memo, my lord.
Arrest memo.
Arrest memo, my lord. My lord, what the CRPC or the BNSS says, my lord, that the arrest memo should be attested by a witness, my lord. No witness, my lord.
There are mistakes they do.
There is no witness, my
We
lord.
should not do these mistakes in these kind of cases. You know.
Yes.
For the prosecution satisfaction, if you want to just take the instruction, that
Yes.
it is not there. If it is not there,
If
it's not there.
then.
Not-
It's not there. It's
not-
a fact.
Yes, ma'am.
Fact is fact.
And
Yes.
in your,
Not to be afraid of fact.
Yes, Lord.
So we'll learn in the future.
Yes.
So that should be there.
Yes.
your lordship had passed a similar order, my lord.
Okay. You can take an instruction. No? problem.
Yes.
Otherwise,
It's allowed.
dispose of.
On Monday.
Let her take the instruction, Mr. Doctor.
Let it be on.
Let her take the second half.
Second.
You need not be present also.
My lord,
Your
my
duty
Yes,
will be
yes,
sufficient.
Second. of-
Second half.
After confirming that, I'll dispose of it.
Yes, Lord. Obliged.
I'm obliged. ma'am.
You give me the judgment.
Yeah,
I'll keep it.
your lordship had passed, my lord.
No, no, don't give me my judgment. You can, this is for reference, but I maintain a compilation of judgments given. Don't get time, try to take it out from the soft copy. Try to study. This is for, only for passing of similar order.
At 2, my lord.
We'll resume after lunch.
Delivery of judgment. IA criminal 112025 with AD 2397 of 2025.
The IA is disposed of and the AB is dismissed.
Dismiss. Oblige.
And good. Yes.
24?
Sometime. Yes. Pass down.
May I please, your lordship?
Yeah.
Lordship charge sheeted NDPS case, lordship, commercial quantity, lordship. Our plea in this case, lordship, the 50 and 50A notice, lordship, which was served to the accused and his relative, lordship, that is, there is no grounds of arrest, lordship. Lordship, may kindly come to page 38 and 39, lordship.
Okay.
This is.
Earlier format.
Yes.
Earlier format. Earlier.
Yes, earlier format, my lord, I have gone through the same and I
Same.
have flagged that, my lord. Even, my lord, I have perused my lord, there is the production order, my lord. Production order, that is, my lord, it is before the learned JMFC, my lord. It is on 9/2/2024. That order also I have flag marked, my lord. My lord, the detailed thing is not there from the order also. So we are not able to find out whether demonstrable prejudice is there or not. But otherwise, my lord, admitted position, no, my lord, thing is there, my lord. So as per Bihan Kumar, my lord.
It will have like. Yeah, Mr. Thakur.
Yes, Lordship.
Learned Counsel. Respect, you can give in Junior's name also, your name also. Yes. The petitioner invoking section 483 BNSS is seeking bail in connection with Gologon space case number 22 of 25 under section 21C of the NDPS Act, which after charge sheet has given rise to special NDPS case number 318 of 24, presently stated to be pending before the learned special judge slash session judge Dhubri. The accused was arrested on 9/2/2024, and since then he is in custody. He is in under trial detention. Good stuff. The learned counsel submits that the main contention is that the notices under section 50/50A CRPC within bracket as it existed then, bracket close, do not meet the stipulated standards laid down by the Honorable Supreme Court. Can TCR has been received, and I perused the said notices from the case record, and the notice, the 50 notice may be reproduced herein below. Eta notice uthai ni. To notice to uthai ni. The 50 notice may be reproduced herein below. Thus, I find that quite clearly the aforesaid nature of the notice given to the accused at the time of his arrest at that time would not meet the standards laid down by the Honorable Supreme Court in Bihan Kumar versus State citation, so as to fulfill the mandate of Article 22 within bracket 1 of the Constitution. Good stuff. It's well settled that in the face of such non-compliance, the accused will be entitled to bail despite the existence of statutory rigors imposed by section 37 of the NDPS Act. Accordingly, the accused is hereby allowed to go on bail of rupees 75,000 with one surety of the like amount to the satisfaction of the concerned learned court, Session Judge Dhubri, and subject to the conditions that he shall be available for the trial. Number 2, he shall not hamper or tamper with evidence. He shall not indulge in any illegal activities, including any activities prohibited by the NDPS Act. Bail petition stands allowed and disposed.
Madam, may I submit one more thing, madam? My lord, along with the my lord, there is notice, my lord.
Yes.
My lord may record, or if my lord thinks, my lord, that is the production order, my lord, also, my lord. That is also, my lord.
That is also, it does not.
My lord, that also, my lord, give no, my lord, that's thing. Also, my lord, as because, my lord, in state of Karnataka versus Darshan, my lord, that ratio is laid down, my lord. So because of that, my lord, I am.
Prejudice.
Yes, my lord.
Should I record as your submission or?
Yes,
my
yes,
observation?
yes,
Also
or
submit.
my lord may, whatever
Uh-huh.
my lord may like.
From the
Because
remand
otherwise law is, my lord, now, that is the settled position of law. That is also, I have flag mark, my lord, maybe a horizontal flag mark, my lord. One horizontal flag mark is there, my lord. Even there, my lord, that is the 51A is not also mentioned in the order.
I've also perused the remand order dated 9/2/2024. And what should I say? That it does not reflect.
My lord, that is also, my lord, that's same contention, my lord. It will not, my lord, clear whether, my lord, that is, my lord, that
The details regarding the reasons for arrest are also not available therein. This fill up the blanks format should be.
yes, my lord, yes, my lord. There's a
I
long,
hope
my lord,
never
earlier
discuss.
ago, my lord, yes.
Sometimes due to paucity of time, we used to sign. the
Yes, sir.
district, but always discourage. It looks bad.
My lord, my lord, my lord. Oblige, my lord.
Deeply.
মাজত সোমাই দিম এই সাবমিশনটো মাজত সোমাই দিম
28
নাইবা লিখিও মই দেখাই দিম
CD was called for in this case, Lordship. Accused was behind the bar since 5/9 charge. It is a case of love affairs, Lordship, it's two teenagers.
Wait, wait.
Has
My lord, in this matter, my lord, my learned senior submitted, my lord, before that, my lord, I would like to draw your kind.
Informant
attention, my
has
lord.
appeared also.
CS, my lord, filed, my lord, in this matter, my lord.
CS file.
Yes, my lord. We get a communication, my lord, that may be kept.
later, once
part of the record.
investigation is complete, Lordship, may consider bail, our Lordship. There is nothing to investigate, Lordship. And secondly, already a compromise has been arrived at, they are going to marry on attaining the age of marriage. Lordship, I have checked the TCR,
Not there.
Lordship.
48 is not there.
40 is there, but it was given in English, but the recipient is a Lordship, illiterate lady, Lordship, she has given the thumb impression, Lordship, as I remember, Lordship. It should be in the language which she could understand, Lordship. This is the direction of the Bian Kumar, Lordship.
Record is there.
Yes,
Record
Lordship.
is there. I have gone through that, my lord. Already flag mark, my lord, all relevant position.
This 47 is not sufficient, so we need not even go into 48.
Yes, Lordship.
Is it,
My lord.
47 is not sufficient. Where is the 48 notice?
40, yellow flag mark is there, Lordship.
Here also, right. Get it. The forwarding. And they did not know, actually. The
Yes.
grounds of arrest have been forwarding, they have mentioned the grounds of arrest. All
My
to
lord,
do
my
is,
lord, here, my lord, let my learned senior
Both with,
and will
paste
submit,
in
my
the-
lord. Thereafter, my lord, I'll make my submission, my lord.
Let's see.
The language, Lordship, they have given in English, Lordship. That's Lordship, I am relying on the judgment of this.
No,
This
where is it? Because the 48 notice, I
48 is notice
Is
is also available, my lord. Both 47 and 48 is notice is available, my lord. There, my lord, along with that, my lord, I have produced the, my lord, order also of the, my lord, there is the
No, this is
production order.
forwarding, I think, brief of the case.
No, 48
No,
notice is there.
48 notice is also there, my lord. Both 47 and 48. First, the notice, along with that, my lord, the grounds of arrest in a separate city in both the matters, my lord.
I see.
In case of 47 notice, in case of 48 notice, my lord.
So according to you, it will suffice?
My lord, it was surprise. Only his contention is that, my lord, the lady
Language.
who is a illiterate one, my lord, that is, my lord, their submission, it is in the, my lord, page, my lord, that is 5 of the petition, my lord, para 5, my lord, relevant para. May I read, my lord? Yes, my lord. That the petitioner begs to state that at the time of arrest, the investigating officer issued under section 47 BNSS accused petitioner as well as notice under section 48 BNSS to relative of the petitioner, wherein the grounds of arrest has been written only in English. The contention is that, my lord, the grounds of arrest is very much there, but that is in English, my lord. As per the observation guidelines of the Honorable Supreme Court, at the ground of arrest has to be communicated in the language which the arrestee can be understand. Now their contention is that, my lord, that the lady, my lord, not only lady, they are stating that, my lord, that is not in English, my lord, both 47 and 48. If my lord may peruse the 47, the notice, my lord, there after, my lord, there is the English language, my lord. SI, my lord, make a, my lord, line, my lord, that, my lord, it was, my lord, read in his, my lord, own language, my lord, translated to his language, my lord. That is there, my lord. And, my lord, the signature of the, my lord, that is the accused petitioner, it is in English language, my lord. Now, my lord, we are not, my
Now
lord,
the
going-
Wakalat, my Lordship, can we see that Lordship?
my lord,
Wakalat
we are
note
not
is
going,
from-
my lord, how many who is educated or not, my lord. Now, my lord, question is that whether this compliance is there or not, my lord. That is on that part, my lord. Prosecution is ready to, my lord, make their submission on that point.
Regarding Lordship 47, that I have annexed on page 24, Lordship, where is the reason of arrest, Lordship?
Both, my lord, the 47 and 48 notice, my lord, I have flag marked.
Actually, they have attached remand.
Yes, my lord.
Remand order with this.
My lord, along with that, my lord, that is the, my lord, all the grounds are, my lord, that is given, my lord, both in the 47 and 48, my lord. Because along with that 47 notice, my lord, grounds of arrest were given, my
I
lord.
briefed the grounds of arrest before the person in local.
Yes, my lord.
Endorsement is there.
Yes, that endorsement is also there. Now, my lord, may kindly peruse the 48 notice, my lord. There, my lord, thumb impression is there, that in the 48 notice, my lord.
Similar endorsement is there in the 48 notice also.
Yes, yes, my
Yes.
lord. In the
Thumb impression.
It was
in 48,
explained-
my lord.
Explained to the person in.
My lord, no, my lord,
That is not
that is not there. Now, my lord, may kindly produce the order, my lord. The production order, my lord. Because it is not before police, my lord, it is before the line at magistrate, my lord. In the second page of the, my lord, that is the order, my lord, production order, the relevant part is there, my lord. Very clearly mentioned.
Court has recorded its satisfaction.
Yes, my lord. Yes, my lord. And not only that, my lord. That is the Honorable Supreme Court's, my lord. That is the decision, my lord. Bihan Kumar, that is also mentioned, my lord. So we have to believe that order, my lord.
Why not?
And my lord, that is the, my lord, after that, my lord, Honorable Supreme Court, my lord, interpreted the law in both the cases, my lord, Kasi Reddy, Upendra Reddy, and also in the, my lord, state of, my lord, Karnataka versus Darshan, my lord. And the ratio is laid down. So, my lord, it is a case, my lord, where the compliance is there, my lord.
The problem is that in the 48 notice,
My
there
lord.
is no specific endorsement like the.
That
first seven.
endorsement is not there, but from the, my lord, that is the statement from the, my lord, accused, my lord, when he was produced before the learned, my lord, JMFC, my lord, that statement is very clear, my lord. Very clear, my lord. And it is not before, my lord, there is a investigating agency, so that, my lord, the coercion is made, my lord.
So according to the prosecution, 47, 40.
Yes, my lord,
Is there.
compliance is there, and that is the, it reflects in the order, my lord.
With commercial quantity.
It is commercial
You have to go
quantity,
with
my lord.
37 then.
Lordship, in this case, Lordship, I have relied on this High Court ordinary bench judgment, Lordship.
Give me.
May I place that? There are 16 and 17, Lordship.
The court has recorded their satisfaction. that they have
Yes,
been-
my lord.
Here the court was, in this judgment, it is said that it is not reflected in the order. Additional CGM has not reflected.
My lord.
But here.
My lord, it is a
reflected.
different one, my lord. We have no dispute
But
on
the
that.
language,
We have no
Lordship, if
dispute
you-
on, my lord, Bihan Kumar. not
Whether,
from
Lordship,
him to
she could
slash
understand
anyone.
that one, that is the contention of this petition, Lordship.
It has to be explained to the person. No, it does not say that it has to be explained to the person in his native tongue. It has to be explained to the person in a language that he understands.
My lord, my lord, my lord.
That he understands. Anyway. So if this thing is not there, then we have to see 37. 37 will have to be seen this. Applicability of 37. Should we, you can address argument on 37 then.
37, Lordship, it's not recovered from this petitioner because, Lordship, his Lordship had that truck, Lordship, and that consignment was, Lordship, it is hidden in the driver secret chamber, Lordship, in the vehicle.
And
Lordship.
he's the owner of the truck.
He's not the owner of the truck, Lordship. He has hired for carrying, Lordship, scrap material, Lordship.
He was not traveling in the truck at that time.
He was traveling, but, Lordship, he was not concise position of that contraband, Lordship.
My lord, may I submit, my lord?
Yeah.
My lord, at that point of time, my lord, contraband was recovered from the conscious position, from the truck, my lord, where, my lord, along with the driver, this petitioner was also very much present, my lord. Now, my lord, that is whether, my lord, his involvement is there or not. Now, at that early stage, my lord, before this bail petition, mini trial cannot be done, my lord, by going through these orders, my lord.
Lordship,
Order, my
charge
lord,
sheet has
we
already
need-
been submitted, Lordship.
Obviously, my lord, charge sheet submitted, my lord.
Charge
We are
sheet
not disputing
submitted,
that
Lordship.
fact,
Now, Lordship, already, Lordship, 4 months has gone, Lordship.
See, the court will have to come to a finding that he
My
is
lord.
not guilty.
My lord.
Yes,
There
Lordship.
has to be some materials to come to a finding
My lord.
that to reasonable grounds to believe that he is not guilty.
Yes,
My
Lordship,
lord.
that is.
Even, my lord, the Caesar witnesses are
Very
there,
tough
my lord.
test. Do you agree?
Caesar witnesses are there, my lord. Very categorically, they have stated, my lord.
What was the contraband? Ganza?
And no, Lordship, it's a Yoga tablet, Lordship.
Yaba, psychotropic substance.
Yes,
My
Lordship.
20,000 suspected Yaba tablets. Total weight was 114 grams. Numbers. Anyway. What is your submission on 37? It is 37 will apply in this case?
Yes, my lord, the commercial
There are
quantity, my
no,
lord.
no, no, there are materials to say that 37, the test of 37 is not passed in favor of the accused in this case, according to you. Only if it is passed in his favor, then it becomes a normal bail application. When you have, where we have flexibility to
My lord.
exercise the discretion. The CD components are here, no?
The CD components are here, my lord. I have, my lord, fact mark those position also, my lord. That is the relevant part, my lord, that is the statements of the Caesar witnesses, my lord. Very much clear, my lord. Both the witnesses are there, my lord. 6 numbers of PWs are there, my lord. And CS dated 27/6/2025.
I'll have to dictate now. Please sit down.
My lord.
10 minutes. Heard B. Chaudhary, learned counsel for the petitioner, and K. Boysa, learned additional public prosecutor for the state. Right? Invoking the provisions of section 483 BNS, the accused petitioner herein, Joinul Hussain Laskar, is is seeking bail in connection with Silchar PS case number 457 of 25. Within bracket GR number 784 of 25 under section 21, 22C. He was stated to have been arrested on 28/4/2025. The case arose out of an FIR dated (28/4/2025), in which it is alleged that based on source information, the checking was laid and vehicle bearing registration number, a vehicle bearing a vehicle in the nature of truck bearing registration number AS 11 FC 7989 was searched, and upon searching the same, contraband in the nature of orange colored powdery substances suspected to be heroin weighing 114 grams were found, semicolon. And 20,000 suspected yaba tablets, within brackets, psychotropic substance was also found. Apart from the vehicle document, full stop, apart from some electronic items in the nature of mobile phones. The learned counsel for the petitioner draws attention to the notices under section 47/48 BNSS in the backdrop of the law laid down in Bihan Kumar versus State. Full stop. It is submitted that the notice under section 48 BNSS was conveyed to the family member in English language, though she has only put her thumb impression therein. Stop. It is submitted that the charge sheet has already been submitted in the case and significant period of under trial detention has already elapsed. On the other hand, the learned additional PP, referring to the relevant portions of the scan case record received, submits that the notice under 47 BNSS is accompanied by the grounds of arrest mentioned therein, and some further submits that the same would suffice the stipulations in law laid down by the Honorable Supreme Court. Stop. With regard to the notice under 48 BNSS, it is submitted by the learned prosecution that the same also contains the detailed grounds of arrest, though the same is admittedly in English language. However, the prosecution has drawn attention of the court to the order dated. Where is that order? Horizon for
28/4/2025 on horizontal flag mark was there.
Order dated
28/4/2025.
28/4/2025, passed by the learned court below, wherein it has been observed where it has been stated that the accused person has stated before the said learned court that the grounds of arrest has been conveyed and explained to his family members. In this backdrop, the learned additional PP submits that there is no infirmity in this case with regard to the compliance of section 47 and 48.
My lord, along with that, my lord, as my lord make a query, my lord, whether, my lord, that is in case of this matter, my lord, because of this 48 notice, my lord, whether, my lord, does embargo of 37 lies or not, my lord, because, my lord, entire thing, it is come out from the Bihan Kumar's judgment. So may I go to the, my lord, those paragraphs only
37
related
apply.
to
37 will apply.
47 applied, my lord.
No, 37 will apply.
My lord, that will apply, my lord, and because, my lord, in
That
the
applies in all commercial quantities.
yes, my lord.
But if there is violation, then that violation ground, bail on the ground of that violation prevails over 37.
Yes, my
In
lord.
this case, it is
That's
applying.
commission. And even if, my lord, even if in the case of, my lord, this case, my lord, regarding that is the 48 notice, my lord, as because it is the, my lord, last part of the Bihan Kumar's judgment, my lord. There, my lord, thinks is that the written communication ground of arrest, like in the case of, my lord, 47, as because it was served to the, my lord, that is accused, my lord. So, my lord, that translation part or things are there. But in the 48, my lord, those parts are not there in 3 paragraphs. May I read, my lord, these 3 paragraphs, my lord? Yes, my lord. Only those paragraphs, my lord. That is the last part, my lord. That is the Honorable Justice, my lord, and Koteshwar Singh, my lord. That is, from the, my lord, Bihan Kumar's.
Supplementary opinion of the.
Yes, that's that opinion, my lord.
Concurring
Because,
opinion.
because, my lord, compliance of this 50A notice, my lord, that was, my lord, discussed on that part, my lord. I had the belief going through the draft opinion of my esteemed brother, Honorable Justice Abhay Oka, and I concur with the analysis and conclusions arrived at. However, I wish to add a few lines in supplement to the aforesaid opinion. The issue on the requirement of communications of grounds of arrest to the
person arrested as mandate under Article 22(1) of the Constitution of India, which has also be incorporated in the Prevention of Money Laundering Act 2022 and Section 19 thereof has been succinctly reiterated in this judgment. The constitutional mandate of informing the grounds of arrest of the person arrested in writing has been explained in the case of Pankaj Bansal Supra so as to the meaningful to serve as intended purpose, which has been reiterated in Prabirpur Kayastha Supra. The said constitutional mandate has been incorporated in the statute under Section 50 of CRPC, Section 47 of BNSS. It may also be noted that the aforesaid provisions of requirement for communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relative, or such other persons of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such information as provided under Section 50A of the CRPC. As may be noted, this is in addition to the requirement as provided under Section 51 of the CRPC. The purpose of inserting 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relatives, or person nominated by the arrested person, is to ensure that they would be able to take immediate and prompt actions to secure the release of the arrested person as permissible under the law. The arrested person, because of his detention, may not have immediate and easy access to the legal process of securing his release, which would otherwise be available to the friends, relatives, and such nominated person by way of engaging lawyers, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives as mentioned above is not merely a formality but to enable the detained person to know the reason for his arrest but also to provide the necessary opportunity to him through his relatives, friends, or nominated persons to secure his release at the earliest possible opportunity for actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to the friends, relatives, or such other person may be disclosed or nominated by the arrested person so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. My lord, now in this case, my lord, 48 notices served, my lord. There is no dispute. Only what is the contention made by the, my lord, the accused petitioner is that the language regarding, my lord, that is the service of the notice under 48, my lord, that, my lord, language part is not, my lord, there, my lord. And here, my lord, from the, that is the production order also, it is very clear that it is known to the relative. That is my humble submission, my lord.
Now regarding lordship, 48 notice lordship, it was an English lordship. How she could understand this lordship? Because this notice 48 lordship prior to the production before the magistrate lordship, before the court below lordship.
We have to also, anyway, where is the production order? Because I lost track.
48 notice kindly peruse lordship that.
That too, like, right, continue the dictation. I have perused the notice under 47 BNSS and considered the contentions on both sides. I agree with the contention of the learned prosecution that there's no infirmity in the notice under section 47 BNSS. As regards the notice under 48 production order. Yes, production order. As regards the notice under 48 BNSS, admittedly the same contains contains the grounds of arrest like the other notice, but it is also in English language. However, One endorsement like that should have been made, but anyway.
My lord, that was not available, my lord. That is admitted
that is
position.
available.
But my lord, law laid down by the Honorable
The-
Supreme
in the
Court is.
notice under section 47 PNSS, the IO has made an endorsement that it was explained to the accused in his language. Such an endorsement is not present in the notice under section 48 BNSS. However, production order will exist. Tag 2 level down. 8. Production order. 28 floor. দেখাই দিয়ক। However, the learned magistrate by the order in the order dated so and so has clearly recorded, has clearly indicated from the statement of the accused that his relatives have been properly informed regarding the grounds of arrest. Therefore, I find that I am of the considered view that the compliance, there has been compliance with section 48 BNSS as well. In the instant case next, as the quantity in question falls in the bracket of commercial quantity, therefore the applicability of the rigors of 37 of the NDPS Act has to be seen. Has to be seen. In this regard, the learned additional PP submits that the present petitioner was also present in the vehicle when when the contraband was seized, and draws my attention to the seizure witnesses. I peruse the statements of the seizure witnesses available in the scanned copy of the case diary. Both the seizure witnesses have stated about the witnessing the seizure of the contraband in their presence from the vehicle in which both the accused persons, including the present accused, was present. Full stop. FSL report is also given? No.
Man, FSL is available.
Must be there.
FSL is available, my lord.
Yes, yes, magistrate order to record. You found the magistrate order. So, in the given, in the backdrop of the aforesaid materials, with regard to the seizure of the contraband, full stop. This court is unable to come to a considered finding to say that on the basis of the materials, there are no reasonable grounds for holding that the accused person is not guilty of the same. Consequently, the rigors of section 37 of the NDPS Act would be attracted to the petitioner, and this court at this stage would be statutorily barred from granting bail to the accused. Accordingly, in the facts and circumstances and in view of in the backdrop of the above discussion, the instant bail petition stands rejected at this stage. The petition stands disposed of.
Lordship, regarding 48 notice, Lordship, that can be reflected because it is an English Lordship and
Yes,
comment.
you can approach, probably let's see how it emerges. But I think this is a case, I think it will not be justified to, grant bail on the basis of 848.
Right.
But then you can test it, actually.
Yes, my.
You can test it, because this is how the laws emerge, We can always be wrong. We can always be wrong.
Highly obliged.
Should always move with that notion in life. This you want back? This you want back, please.
30.
32 30. Speed jump হবে ছিল. Yes, Mr. Roy Chaudhary.
Malad, the FS starts at page 10. I was the driver NDPS arrested on 1725. FIR relevant is at page 13. No, it was not recovered conscious position from me. I was a driver. Some Yaha tablets.
Similar.
My contention was that of, in paragraphs we have said about that, Marad. The-
Number 38, please, very not received.
Case diary or record?
Yes.
It's at the stage of, okay. Scan copy of trial court reports.
Not received, my lord. Case diary, my lord.
In this case also, this determination will have to be made, right?
38, no? Even number.
37 determination will have to be made.
30, my lord, scan copy received. 30,
Hmm?
item number 30, scan
Asmat
copy.
Ali.
Asmat Ali. 30, Baidu session. Kindly taken up after some time, my lord, the scan copy has been gone through by learned APP Sapnabar Hazim. Yes.
Can it be on Monday or Tuesday? Because
Yes, well, on Tuesday.
we don't have so much time. on-
Yes, on Tuesday.
Is it okay if I fix it on Monday or Tuesday?
Tuesday, my lord. Monday list has come out. So Tuesday, always.
The scanned case record has been received, but learned additional PP 6 some time to go through the same. This is the matter on 28/10/2025.
Obliged.
May I please, Your Lordship? Your Lordship may kindly grant us 1 week time to file an objection in this matter.
Your Lordship, we have submissions to be made because the 813 days is behind the bar, Your Lordship. So,
Objection is
21
necessary,
C.
Your Lordship, in this matter.
yes, sort of. The trial is also there.
Trial is started?
Yes, 14 occasions, no PWs have stand up, Your Lordship. And 4 witnesses has already been examined out of 10 witnesses. So nothing has been whispered against him. So he is languishing behind the bar since 313 days, 813 days.
How much time you want?
1 week time.
1 week's time?
Lordship may fix a date.
Yeah, we can fix a date. Miss A. Hussain.
R. Hussain.
R. Hussain. Learned, Miss R. Hussain, learned counsel appearing on behalf of the
Mr. SCK.
NCB. NCB / prosecution. 6 a week's time to file a written objection. Prayer is allowed. Full stop. The learned petitioner counsel has submitted that the accused is in custody since 1/8/2023.
Yes.
1/8/2023, more than 2 years.
Yes.
It is further submitted that however, trial has progressed to a reasonable extent. Anyway, that's good. So this is the matter. On when should we fix it? Okay, take it on.
29th or 30th.
No, okay, fix it 29 or 30th. Don't take it on 31st, okay? Yes, I think it's
31st.
on leave that day. 30th or, okay.
31st.
How about 3rd Monday? 3rd of 3/11.
Third.
That will be 3/11. You have full 1 week, you file the.
If your Lordship can kindly fix on 31st, if you.
31st, I have some, I may not be available. Another quarter will be there, but still.
Deeply obliged.
All right.
May I please, Lordship?
Regarding
For
item
83
number-
application.
Yes, well, regarding
for
item number
granting bail to the
32, my lord.
petitioner, Lordship.
Well, regarding item number 32, my lord, just now, my lord, I have received the instruction from my office that, my lord, before some time back, my lord, CD received by our office today only.
CD has been received.
CD received by our office, my lord, the before. On, your lordship may
My
pick it
lord,
on Monday or
36
Tuesday.
days. I'm behind the bar, Lordship.
You are for the informant.
For the.
So let us give some time to them to see, peruse the case diary, right? Just been received. Okay. So submitted by a prosecution that that it has been informed that the case diary has just been received in the office. Right? And 6 some time to go through it. When can we fix it? Monday or Tuesday?
Or Tuesday, my lord, Tuesday.
This is the Tuesday.
Tuesday.
List on the 28/10. Of the. May
I believe that.
So it's a 483 application, Lordship. It's a second bail application before a Lordship, Lordship. Earlier it was rejected, Lordship, on 3rd of
Just a minute, the file is not come. 33?
33, Lordship.
33 and my lord earlier, item number one is also my lord same.
One we have disposed.
No, my lord.
Oh.
At that point, one.
लिखा सर You, I should take up 33, no? Yours is 33.
My one, Abdul Razak, Abdul Razak.
33 Abdul Razzaq and Alimuddin.
You are appearing for? in-
I am for, my lord, Abdul Razak, Lordship. Abdul Razak. Abdul Razak application was rejected on Lordship 17th September, Lordship. Lordship, on the basis of an FIR, Lordship, which is a 12, Lordship, page 12, Lordship. I was arrested, Lordship. Merely on suspect, Lordship. I was not the Lordship name accused, Lordship, FIR name accused, Lordship. There is only one name accused, Lordship, in the FIR. Is his Lordship personally, and he has been granted bail, Lordship, by the court below, Lordship. Lordship, my fresh ground of this bail application is that, Lordship. Earlier, while my bail application was rejected, Lordship, period of detention was, Lordship, 44 days, Lordship. Now it is, Lordship, 83 days, Lordship. In the meantime, Lordship, the court below, Lordship, has granted bail, Lordship.
The FIR named accused.
Lordship, to the FIR name accused, as well as the accused who is arrested, Lordship, on suspect, Lordship. And more so, Lordship, if your Lordship kindly come to the bail rejection order, Lordship, which is at Lordship, page Lordship 20, Lordship. Here the Lordship, on the basis of materials, which indicates that there is Lordship, telephonic Lordship, linkage Lordship, and statement of some arrested accused, Lordship. That is not relevant, Lordship. That cannot be the ground for uncountable detention, Lordship. This is only my fear, Lordship. Already 83 days, Lordship. And co-accused has been released, Lordship. I am
That order is
arrested.
there. I think you have annexed that order.
Lordship, I have annexed, Lordship, the orders. Order is bail granted to co-accused is page 23, Lordship, by the court below, Lordship. And the anticipatory bail granted to the name accused, which is at page, Lordship, 27. He is the name accused, Lordship.
Okay, you see the investigation after the last order, 17-9.
Yes, there is not up to date, my lord. There is regarding the present accused persons at that point of the materials is there, my lord. He along with both the accused persons in item number 33 and 1, my lord. Although name of the Pasan Ali is there in the as per the submission of the my lord, friend, my lord. Pasan Ali is the contractor, my lord. At that point of time, all those some of the laborers were working there in that house. Thereafter, they knows well about that house, and thereafter, my lord, on that night, that incident of dacoity occurred in the residence of the informant, my lord. And during investigation, my lord, and during technical analysis also, and regarding one of the present accused Abdul Razak, my lord, criminal antecedent is also there, my lord. Earlier, he was arrested in one dispute PS case number, my lord, 1080 of 24 in the year.
What kind of offense, that one?
Well, that is not specifically mentioned here, but only the case number is in the case.
Lordship, that cannot be the ground for detention, Lordship.
Otherwise, not
This time-
that is not only the ground, my lord. There are other materials also, my lord. From technical analysis, my lord, my lord, in the earlier order, your lordship, everything has been.
No, that is a relevant factor. Supreme
Relevant
Court has
factor.
recently also
Yes.
given a judgment that
Yes.
they have
Criminal
asked the high courts to incorporate a rule in
Yes.
any previous antecedents have to be mentioned in the bail application.
Yes.
Trial, it won't be.
Only that is not only
It
the.
may be in sentencing
Yes.
in some situations, but not in finding of guilt. That would be unfair.
Yes.
But for bail, it may be to some extent, not wholly. But mainly you should focus on the case before you. Anyway, so The allegations were quite serious actually. Dacoity at midnight in the house of a senior citizen,
Yes.
in which they were also almost tried to be harmed as per the allegations.
The main accused person, my lord, accused number one, Alimuddin, along with my lord Alimuddin SK, along with Shah Alam, Mohidul, they all are involved in my lord planning this dacoity, and thereafter, my lord, along with the laborers who were working there, also some of the laborers also involved, and my lord, they executed the plan, my lord.
But the present accused is nowhere involved, Lordship, in this case, Lordship.
And the vehicle of the present petitioner was also used, my lord, one my lord scooter and my lord.
No, no, the investigation findings are more important.
Yes, my lord.
Kindly,
Would you like to make the submission with regard to the other also? Make it.
Other accused, he is also my lord, along with Abdul Razak and the
Similar.
present Alimuddin, yes, my lord, he is also one of the main kingpin of the.
Investigation, how far it has progressed?
Investigation is my lord, going on other, some of the, but those articles were not yet recovered. Regarding recovery, there is nothing in the case there, my lord. Their statement also, my lord, they admitted how they committed the offense along with them, who are the persons, my lord. Regarding that aspect also, there are materials.
And have a
Those
look.
although those are the statement of the accused persons, but they, my lord, vividly described, my lord, how, along with whom they have committed the offense.
Other criminal cases pending against which one? Alimuddin or this?
Alimuddin, my lord. Alimuddin Sheikh, yes.
I am Abdul Razak, Lordship.
33 is Abdul Razak.
Can I have a look?
Yes. I have flag mark, my lord, specifically about Abdul Razak and Alimuddin SK, my lord. Flag mark.
If your lordship kindly come to the page number 25 of my bail application, lordship.
Yes.
Paragraph number 7, lordship. Only on that count, lordship, the co-accused has been lordship granted bail, lordship. And the present accused will also lordship cooperate in the investigation, lordship. Only on that count, lordship, bail application has been granted. And lordship, the present accused has 83 days, lordship. And the co-accused is released below 30 days, lordship. At any condition, lordship.
No, page 25 is a rejection order. This is the allowing order. Page 25 is the co-accused bail, which page?
Lordship, 25, lordship. No, lordship, Abdul Razak case, lordship, 25, page 25, paragraph number 7, lordship.
Page 25 is, acha, this bail petition.
Page 25.
Oh, this one.
Lordship, only on that count, lordship, bail has been granted, lordship.
Page, para?
Para 7, lordship.
Okay, I'll see it again. Do you think the custody is necessary or can be allowed? Because, materials are there, no doubt.
Materials are there. Regarding my lord
Serious,
granting of bail to Akhtar Hussain and Sanidul Islam. my lord,
Materials are there, no, we have to decide on other grounds.
Yes.
If at all. There are
Because-
materials.
Main problem is difficulty is that my those articles were not yet recovered.
The investigation will be hampered, then it's another matter.
Will not.
Difficult to decide. দেখি অমিত আমার আগরটা পাঁচটা পা লৈ ললো থার্ড প্যারাগ্রাফ মানলৈ লৈ লব allegation ছিল. So, the learned counsel for the petitioners submits that an earlier bail petition was rejected on 17/9/2025 after perusal of case diary. Peruse the annexed order. Full stop. By way of subsequent grounds, the learned counsel submits that the length of detention as on date may be considered. And two co-accused have already been granted bail by the learned court below on 19/8/2025. The case diary was called for again, and learned additional PP submits that the investigation has reveals significant incriminating materials against the accused persons and indicated their involvement as part of a gang indulging in such activities, such offenses against property. Full stop. The particulars of one case pertaining to Dispur police station has also been mentioned. So therefore, there is no doubt that there are significant incriminating materials against the accused revealed by the investigation. Nevertheless, I also find that there is sufficient progress in the investigation. And perhaps the investigation is, it's nearing conclusion. Full stop. In keeping in mind the said aspect of the matter and also the additional length of detention since the date of last rejection, I'm of the considered view that subject to suitable conditions, the accused can be granted bail. Accordingly, so and so 50,000 with one surety, to the satisfaction of the concerned learned court, which will be Hatigaon, right? This is Sanmari, CGM Kamrup Metro. And subject to the conditions, number one, they shall not abscond, they shall cooperate with remaining investigation. He shall not hamper or tamper with evidence. He shall not misuse his liberty to commit any illegal activities or offenses, including any offenses, offenses against property. Stop. Return back the case diary, bail petition stands allowed and disposed of. This is similar. Similar, just a minute. Yeah, or rejection orders, I think, or different.
24 times.
Yeah, this is item. Yours.
Item
One, item one, Ali Muddin Sheikh. It to 33 asil. 33 asil. It to one to Ali Muddin Sheikh. The rejection order to be like.
Is number 24.
Yes, I found. But yeah, right. 24/9/2025, no? Date of rejection, page 24. And সেইটো দিছপুৰ PS কিবা এটা লিখিছিলো যে সেইটো নালাগে I have not found. সেইটো নালাগে second one. পোৱা নাই I found the earlier case with regard to the previous accused, not this one.
Yes, Malad, I will have to again.
No, the dispute PS with regard to the other accused.
Yes, Malad, yeah, dispute
I
only
could
in
not
respect
find
of
it.
Abdur Razak,
Yes.
Malad, item number 30.
Allowed and disposed of, same terms and conditions. 1 and 33 disposed of, 1 and 33. To go a little fast. Orders I can touch and admission. Yeah, next 34.
My submission.
Yes.
May I please lordship? My lord, the petitioner is behind the bars, my lords, for 45 days, my lord, and allegation made in the affair is that, my lord. Why, my lord, I was traveling by train, my lord. One bag, my lord, containing, my lord, 4 kg, 257 grams of cannabis was recovered, my lord. But as per my instruction, my lord, I was not possessing that bag, my lord. And, my lord, affair itself, my lord, reflect that, my lord. Seizure was not made at the place of occurrence also, my lord. And I have been already interrogated and seizure also has been made, my lord. So I think further custodial detention may not be required, my lord. And I'm the first time.
He was arrested on 10/9.
Yes, my lord. And another aspect, my lord. My lord, I could not collect on time, my lord, that grounds of arrest, my lord, which 47 and 48, my lord, were supplied, my lord, but on English, my lord. But in the, my lord, arrest memo, my lord, my wife signed, my lord, in Assamese, my lord. I also signed in Assamese, my lord. We don't know the English language, my lord. That I have not mentioned in the petition because it was not supplied to me on time, my lord. So, my lord, already 45 days. I will, my lord, face the time if Sarsi is filed, my lord.
Yeah, in this situation, 37 is not applicable.
Yes,
So we have more flexibility.
Yes.
Respective
Here,
of
4
the
kg.
compliance. 4 kg is something of ganza.
4.57
Ganza.
gram of cannabis
10/9
recovered
was
from the possession of the present petitioner, my lord. And regarding, my lord,
In train, my lord. In train.
10/9, yes, 10/9/25.
Any strict condition may be imposed, my lord.
Seizure is supported.
Yes, seizure
Progress,
is-
progress is there.
FSL report not yet received.
But otherwise investigation. is-
Otherwise, investigation substantially progress and, my
I
lord,
will not peruse,
Yes.
basis of your submission.
Yes,
So there's some time constraint. 483, লিখি দিবা। Rangapara GRPS case number 22 of 25, 20G. Petitioner was arrested on 10/9/2025. Pursuant to recovery of suspected cannabis ganza of approximately more than 4 kgs from him while he was traveling in a train, from the train, right? As stated in the FIR dated 10/9/2025. The case diary has been received. The learned additional PP submits that the seizure and allegations have been supported by the seizure witnesses. However, investigation has progressed and appears to be pending only for FSL report. in the circumstances, the accused so and so is hereby allowed to go on bail of 30,000 with one surety. Like, inspection conditions, hamper or temporary evidence, remember, influence witnesses, right to influence, not indulge in any illegal activities, including in activities prohibited by the NDPS Act. Violation allowed in this course.
Special, special just.
Kamrup.
No, my lord, Sunit.
Yeah, so the concern to the satisfaction of the concerned learned court within bracket, session judge / special judge Sunit. I know.
35. Made use of lordship. This one is shown arrest on 28/8/2025, my lord. 2 days, 57 days, my lord. Mandatory period is 60 days, my lord. Affair is space, my lord. 14, long affair, my lord. I have stated in paragraph number 3, my lord. May I read, my lord? On 5/3/2025, the
Para 3?
Para 3, my lord. On 5/3/2025, the informant namely Kishanu Deka, who is the one of the employees of the Bajaj Finance Limited, lost an azhar before the Gorshuk police station inter alia, alleging that one Amit Kumar Sharma, I am not Amit Kumar Sharma, my lord, I am the Obimanyu, to whom a loan was given for purchase of vehicle Mahindra Thar so and so bearing registration number so and so by way of executing an agreement for a loan of one so and so. The said Amit Kumar Sharma not only failed to make payment of monthly EMI but also predominantly sold the vehicle which was still under hypothecation by way of creating false document and also got the registration of the vehicle transferred from the Transport Department Kamrup to Transport Department Himachal Pradesh. This is the fact, my lord. I am the my lord Obimanyu, my lord. I am not, my lord, Amit Kumar Sharma, my lord. Today is 57 days, my lord.
Why was he arrested? You have the foreign.
Shown arrest 28/8 to
Shown arrested in this case, my lord.
Forwarding is there.
forwarding, my lord, page 18, my lord.
Page 18. And earlier rejection order of the trial court is at page 19.
Earlier rejection trial court order, my lord, page 19, my lord.
Forwarding report, I think they have wrongly mentioned, no? Incorrectly mentioned that he's FIR name. He's not FIR name.
I'm not aware, my lord. My lord, ground number 1, my lord, the below noted accused person, FIR named accused person. I'm not a.
It weakens the credibility, no?
My
This
lord.
kind of mistake should not be made. This is copy pasting, but still, that small difference is important.
Not today's 57 days, my lord.
That has come?
Yes, case diary received, my lord. I will point out you to your lordship, my lord. Your lordship may kindly first, before my lord pointing out what are the materials against the petitioner in the case diary, your lordship may kindly peruse page 21 of the earlier rejection order of the trial court, my lord. I will point out what the accused person, a bare perusal of the case diary reveals that the above named accused is actively involved. So the vehicle, my lord, the FIR is lost by the, my lord, by Bajaj Finance Limited. And the allegation is that, my lord, the vehicle is already in hypothecation in the name
You
of
cannot
one
sell.
Amit Kumar Sharma. Now, while the vehicle is already in hypothecation, what this accused person has done, the vehicle is transferred to, my lord, by forging document of the NOC of the that finance company, the Bajaj Finance Company. They have transferred the vehicle in the name of some person of Himachal Pradesh, my lord, to the, my lord. So, my lord, this is a serious offense, my lord. A vehicle which is already hypothetically with Bajaj Finance Limited, already, my lord, registered, my lord, here in the Kamrup, my lord, and by forging NOC of that finance company limited and forging other documents, my lord, while the vehicle is still under hypothecation, all those installments of that finance company is not yet paid, my lord. They have transferred the vehicle,
Huge loss for the
and the
finance
present person is the mainly responsible, my lord, by using by forging those. And your lordship, I would like to point out one of the important, my lord, witness, my lord. He is the present petitioner is the person who submitted all these documents, and thereafter, my lord, along with the NOC, my lord, forged NOC, and thereafter, my lord, vehicle is transferred in the name of someone of Himachal Pradesh, my lord.
Main accused, my lord, Umit Kumar Sharma, my lord.
Not Amit Kumar Sharma, my lord. He is also involved, my lord, because the vehicle is in his name. Both the accused persons are, my lord. Your lordship.
My lord, on the ground of length of detention, my lord, 2 days, 57 days, my lord.
He specifically stated that the Abhimanyu Das is.
The statutory period is 60?
60 days.
90 days.
60 days.
60 days, my lord.
Topper should be soft. Right. Bring them.
3182.
Cross check it once.
336.
So it's, it will be over by the time we reopen on Monday, it will be over.
Yes, yes.
Unless you want to keep the person in custody despite filing of charge sheet.
Yes.
Then it will be justified to deny bail. That even after charge sheet, you want to keep him in under trial detention. Otherwise, not serve much purpose.
Yes.
Materials are there.
Yes, I'm just pointing out
Materials are
the
there.
materials.
I am paying for on the ground of length of detention, my lord, 2 days,
Yeah, fair enough.
Yes.
57 days, my lord.
You can always contain about length of
My
detention.
lord.
Yes. Only on that ground, my lord, length of detention.
Length
Otherwise,
of
I am
detention.
pointing out the materials, my lord. What are-
Sixty days.
Yes,
60 days.
60 days of.
Yes. M. Hawk Learned Council and B. Botagon. 483 application. Gorsuk PS
No,
case
no,
number
no.
91 of 2025. Time বসাবো লাগে। You have to save. তুমি লব পাৰা page 91 চাবা second paragraph লব পাৰা।
আপনি কই দিয়ক না।
না মই ঠিক আছে মই দি দিম short কে দিম। This is also long.
দুটা দিছেন।
The gist of the allegation in the FIR is that the named accused and others fraudulently sold hypothecated vehicles of Bajaj Finance Limited by forging documents. So, though the present accused was not initially FIR named, but he was arrested, subsequently arrested during investigation. So the case diary has been received. The learned additional PP submits that the investigation has revealed sufficient incriminating materials against this person also, the present petitioner also, and that he has been found to be involved in manipulating documents, no objection, NOC documents and others purportedly of the finance company to transfer the vehicles. And one such vehicle was sold to a person in Himachal Pradesh, HP. Full stop. From the case diary, the investigation appears to have progressed well. Keeping that aspect in mind, despite the adverse materials, considering the progress of investigation and the length of detention of 57 days, full stop, vis-a-vis the applicable statutory period of 60 days, the accused herein is allowed to go on bail of rupees 50,000 once every, subject to the condition that he shall cooperate with remaining investigation, shall not hamper or tamper with evidence, shall not try to influence witness. Case of violation, bail will be liable to be cancelled.
CGM Kamrup Metro, my lord.
Yes. Timing আছে নি? এটা। এটা বহুত আছে।
61, time B. 61.
Commercial quantity is not possible to go very fast also.
The 61 minute.
You have to see inside. Anyway.
Here, my lord, instruction was sought for regarding.
Yes, my lord. I have
Can you-
received the instruction, my lord. In this case, as per my instruction, my lord, Search sheet submitted, my lord, today.
Like cooperate with the trial, my lord, in any condition, my lord.
483 short के लिखना 483 हम ही short लिख लोगे 483 DNSS format लिख लो Paul Woman PS case number 74 of 25 he was arrested on 26/8/2025 the learned additional PPS placed a communication received the communication dated 24/10/25 received from the concerned PS stating that pursuant to completion of investigation charge sheet within bracket CS number 67 of 25 dated today only charge sheet has been
Yes, ma'am.
24/10/25 has been filed.
That may be kept as a part of the record.
The same may be kept in the case record. In view of completion of investigation, the accused is allowed to go on bail of 30,000 with one curate. The like amount, satisfaction of the
Kamrup Metro, my lord.
subject at an additional condition of the lay. Hamper or temporary evidence available for trial. See, he shall not in any manner threaten or harm the informant slash victim and the family and her family. Bail petition stands allowed and disposed of.
CGM Kamrup Metro, my lord.
CGM, concerned lawyer.
Obliged, my lord, highly obliged.
Next is your lordship.
Diary is come, finally.
Yes, my lord, case diary received.
The AB.
Three of the co-accused has already been listened to, my lord. My name is serial number 6.
Diwan Nazmullah.
I'm not the main accused, my lord. Main accused is
Right.
accused number 1, Devan Farhad Ali. It's clearly stated in the FIR, page 8.
Yeah.
It is to be mentioned here that the advice and cooperation of the accused person, 2, 3, 4, 5, 6, 7, and 8. The accused number 1 has killed my father. Killer is the accused number 1. And the accused number 7 and 8 exactly similar to my conditions and circumstances.
You are for the informant?
Yes.
here case diary received, my lord. Here from the PM report, my lord, PM report also received. My lord, death was due to hemorrhage and shock resulting from injuries sustained on chest. All injuries were antemortem and caused by sharp cutting pointed weapon, my lord. My lord, before the incident, here the incident happened on 26/6/2025. Before that, my lord, earlier that on 24/6/2025, the accused person threatened the victim, my lord. And thereafter, immediately after 2 days, along with all these accused persons, he is FIR number 6 of the in the FIR, my lord. And one Farhad Ali, my lord, who stabbed the victim multiple times, my lord. He is the Farhad Ali is one of the.
He's accused number 1.
Petitioner, he accused number 1, my lord, Farhad Ali. Farhad Ali, accused number 1.
Yes, killed by father.
Yes, the one Farhad Ali is accused number 1. The petitioner is accused number 6, my lord. And there are evidence of the witnesses, my lord. On that day, my lord, the present accused persons also accompanied the accused number 1, and they were present at the place of occurrence, my lord. And thereafter, some of the witnesses that at that point of time stated that accused number 1, my lord, he stabbed at that blow. But all these accused persons were accompanied the accused number 1. And thereafter, all these accused persons from 1 to 8, my lord, they are all, my lord, in the FIR, their name is there, and he is accused number 6, my lord. There are statement of witnesses also named the present accused, my lord.
I'll have a look.
And regarding Farhad Ali, yes, my lord, on the ground of that is, my lord, bail application here annexed, my lord, Learned Trial Court has granted him bail for non-compliance of, my lord.
No, he said 47 and 48.
Farhad Ali has got bail.
Lordship.
My one bail petition, my lord, the petitioner has annexed, my lord, in the petition.
On the ground of Dhyan Kumar Das, the accused number 1.
Anyway, you can submit.
And my lordship, your lordship has earlier also taken up consideration for 2 other cases, lordship, where lordship has rejected on the ground that accused persons were present at that place of occurrence at the time of offense, lordship. And lordship, and this accused person is also present, lordship, to my instruction, lordship. And lordship has rejected also, lordship, 2 accused persons on that ground that there may be vicarious liability that accused persons. So lordship, I think lordship,
Can I have a look at that?
Yes,
yes,
yes, lordship. And had it been a case of under 483 lordship, that lordship matter would be different. Since it is a 482 application, lordship. He was also present, lordship.
Yes, well, all the accused persons were present at the time, and they were in fact accompanied the accused number 1, my lord. And in fact, that, my lord, everything was premeditated, my lord, because earlier, before the incident, my lord, before 2 days, earlier, my lord, those accused persons threatened the deceased, my lord, and thereafter, after 2 days, this incident happened.
Order of AB 1921. First trip at 1, 2, and 3 to repeat. 1, 2, and 3 allegations. It was again allegation. I'll dispose it of. Stop. The learned additional PP submits that the case diary has been received. After going through the case diary, he contends that the involvement, the presence of the present petitioner at the place of occurrence at the time of the incident, and his involvement, his presence of occurrence and his association with the other accused persons, including the main accused, has been found by the investigation. Full stop. It is submitted that the investigation has revealed that accused number 1, against whom there are direct allegations in the FIR, had stabbed the victim several times as per the materials revealed by the investigation. the complicity of the other accused persons, including the present petitioner, has also been found as per the investigation materials. Mr. So-and-so. Learned counsel for the informant, learned counsel for the informant, opposes the bail and submits that all the accused persons, including present petitioner, are involved in the occurrence. Full stop. He submits two orders of this court wherein the pre-arrest bail paid for on behalf of two co-accused have been refused. The learned additional CP has also submitted that the investigation materials has lent support to the contention in the FIR that on 2 days prior to the incident, the victim was threatened by the accused persons and was threatened with death by the accused persons. And 2 days later, the present alleged incident took place. In the given facts and circumstances, I'm of the considered view that this may not be a fit case for grant of anticipatory bail, as investigation is not still going on, especially as investigation is still going on. In such view of the matter, the bail petition stands rejected at this stage, returned back the case that disposed of. Next. Bail can he call it? No problem. None appears on call. Scan TCR is received, right? Scan TCR. Scan TCR is available. So please the matter. When should I fix it, this matter?
My lord, 7/11, my lord,
A little earlier.
earlier on
The ABD.
4/11.
311.
3/11, yes.
311. Busy also somewhere.
65.
April.
May please your lordship.
Yeah.
In anticipatory bail application, your lordship had heard it day before yesterday.
Oh, yes.
Yes,
I
my lord, my
remember.
learned friend was supposed to address.
As much as notice under 48, BNSS has not been conveyed to the relative, thereby violating the rights under Article 22(1) of the Constitution. And consequently, the accused has become entitled to bail in terms of the law laid down in Bihan Kumar, Pura to likhe dibo. Full stop. This is also despite the existence of the statutory bar under Section 37 of BNS. It may be mentioned herein that in Bihan Kumar Supra, it has been held that once a person is found to be entitled to bail due to violation of the aforesaid constitutional provision, his entitlement to bail would remain despite the existence of statutory restrictions on bail. Accordingly, the backdrop of the aforesaid discussion, the accused is allowed to go on bail of 50,000 with one surety of the like amount to the satisfaction of the concerned learned court with an additional session judge Kamrup Anand. And subject to the conditions, did you know? Conditions, my guardian. He shall, it's at the stage of trial.
Yes.
It shall be available during the trial. Number 2, he shall not hamper or tamper with evidence. He shall not try to influence witnesses. He shall not indulge in any illegal activities, including any activities prohibited by the NDPS Act.
I am obliged,
And
deeply obliged.
main thing is the trial.
Only the sad part is this, these are the commercial quantities, lordship.
Yeah.
Only because of technical flaws.
In a way, they are lucky.
That is the only sad
there,
part.
but I see, I'll tell you something. The main thing is the trial. If
Yes.
Some people, some additional people get bail,
Yes,
heaven's own fault. We should never look at it like that.
Yes.
Actually. Commercial quantity, there is a philosophy why people are being kept behind, but the philosophy, there's a twin philosophy that
Yes.
you're not being granted bail,
yes,
but the other part of the philosophy is that trial should be speeded up.
yes,
That is not happening.
yes,
So if you,
yes.
all those cases where bail cannot be given statutorily, trial has to be speeded up.
Yes.
Speeded up.
Otherwise,
Within a year, it has to be
it
completed.
has found from the conscious position of the petitioner.
Yes.
That's what,
But the circumstances.
yes,
There are circumstances.
yes, option of life.
It's nobody's failure that way. The law has changed. It's 30 leftovers. Roy Chaudhary. Where did he say? Instructions were there. No, September I had already. Tuesday we'll fix it.
65.
You will submit? That's.
Yes,
On this
Melo,
I will
regarding, yes, Melo, on that day, your lordship had asked me already regarding FSL report.
Yes, so at that time is 55 years, man. Last 56 years, man. I am only minor because ultimately there is no chance of hearing matter, and only just because more than 2 years already.
Okay. You got the wrong file.
Yes, ma'am.
What happened?
Yes, ma'am. Some
I
ND,
have given my lot to you.
I have got one NDPS case, ma'am, of item number 52. And conviction is of 10 years, so ma'am,
Yes, yes.
I will have to go through in detail. ma'am.
The petitioner counsel, learned senior counsel is on the, on this delay. He's not into merits.
Yes, no.
Because if we go into merits, we have to go into.
Matter, no, not on matter. I'm exact matter, one day Supreme Court has said matter, I think matter fixed term appointment. That your lordship always consider in another case matter. There is no chance of hearing also, my.
Otherwise, your lordship may fix it for final hearing, well.
That is not. Last time one is same question.
Okay, this I had seen, I thought it was normal bill.
Document. matter.
Oh. Two have been granted.
Yes,
bail.
yes, ma'am.
What happened? Two have been granted. bail.
More than 1 year ago, my.
Two have been granted.
And
That is a
at that
factor-
stage,
That is a factor in your favor.
Yes.
sort of. No identical situation has been. We have very little time actually now.
But,
Yes,
One part is already complete, but if you,
2 years, 1 month, 6 days, ma'am.
there 1 month.
And earlier it was 1 year. ma'am.
Yes, 2 years, more than 2 years.
এইটোতো আপোনাৰ এইটো কেছ নহয়, এইটো কেছত কৰা নাই, এইটো কেছত বিল গ্ৰান্ট কৰা নাই। গম পাইছো। Otherwise, my lord, regarding that, my lord, on the basis of that Supreme Court judgment, my lord, regarding suspension of sentence, if my lord, it will take
Fixed term.
time. So, my lord, I will have to go through the detail in that judgment because I have not gone through the judgment of the Supreme Court, my lord. If my lord, in
That
that,
I forgot.
Otherwise,
That
my
was
lord,
which year? This was I
Uh,
judgment?
2025, my lord.
25, 1 at 20. Your
25.
lordship it is there, your lordship.
Sorry, didn't I? No, no.
It is mentioned, my your lordship earlier or.
Oh, no, no, not that one. That Supreme Court judgment, that is a which year? I forgot.
2025, my lord.
That is in your,
Criminal appeal number
that is available in lordship
1445.
for our, which you have just now given. Who judgment you
Oh,
have?
so this one, this one.
Yes, this.
Kartik Pandit.
Yes,
Kartik Pandit. It will have a neutral citation.
Yes.
It will have a neutral citation.
Yes.
And the other one is 99, I think, man. Kartik Singh.
Otherwise, my lord, there are various earlier judgments of the Supreme Court. which also-
Previously, there are many judgments.
Yes.
Many
Yes,
judgments.
yes.
But I think this is not overruled. Bhagavan Sinde Gosai is not overruled.
Yes.
actually. Holds the
Still,
field.
man, still.
Holds the field.
Only when a fixed term, no chance, just last time, Lord, she was also my lord. No chance of
And that
hearing.
is true.
And even if it takes time, it will make no difference, my lord. Fixed term, man. Because I am not just going to marry it also, my lord, I am not saying, man.
You want another day, sometime?
Any short date, my lord, as per the
On
complaint.
Tuesday, you can,
Yes, Tuesday, my lord, Tuesday.
but it has to be, should I keep it as part heard or?
Yes,
Because otherwise it will not reach
yes,
my
your
lord.
lordship
That's
may
the
keep it
biggest
as
problem.
part of-
I-
your lordship may keep it as part on Tuesday, Wednesday, my lord, any day.
But he has only submitted this part only. Anyway,
And add to your lordship that maybe very good.
the learned senior counsel is assisted by learned counsel Ayu Chaudhary addresses
Just section to that.
arguments on the interlocutory application seeking suspension of sentence and bail.
I am, I'll extra sin copy.
It is submitted that that the learned senior counsel has submitted that he would not go into the merits of the matter at this stage and only seeks bail, suspension of sentence and bail on the ground that there is no possibility of immediate hearing and disposal of the appeal. In this regard, reference is made to the judgment of the Honorable Supreme Court in the case of so-and-so Gosai. The learned additional P. Bodhakur submits that he may be given a short time to go through the cited decisions and make his submissions. As the prosecution has also filed a written objection, right?
Yes.
The objection is on the matter.
Already filed though.
So the prayer is allowed. List the matter on 411. We can take it.
Four-
No, my lord, Tuesday, my lord,
2810.
28.
2810.
At 2, my lord, your lordship, otherwise it will not reach one. Since part.
On 29/10, my lord.
29/10.
29/10.
I want to key. I want to key, wo kabhi na. It will make no difference.
No,
2910. No, but this 2910 is motion day.
motion day, then Thursday, my lord.
31st. I
Oh,
may be on
parcel
leave.
is in custody, my lord.
Yes,
I may be on leave.
yes, on 28, my lord.
2810.
20.
Obliged to us.
Just on 2810.
At
So
2, my lord,
endeavor,
otherwise it will not reach one.
So it is submitted by the learned senior counsel that endeavor may be made, may perhaps be made by the court to take up the matter at or around 2 p.m.
Obliged to us. But a similar 67 is same on the same, yeah, my lord. That also may come on Tuesday, my lord. I'm not asking today, my lord.
No,
Your lordship exhausted already.
no, yeah, there'll be no time because this is, we've kept it part heard. One by one, let us go there. Let it come up on 30th. Thursday.
67, item 67.
30th.
Obliged,
Paucity of time, 30th, 30.
obliged. This is your 10.
30. 30th. Itu to 2 p.m. to nalage. Itu normally 30th. Okay. So,
Maybe
you make the mentions.
in the morning.
Actually, I
Lordship-
should stop 10 minutes early, no?
Yes,
So that the mention times are also
Yes, yes.
covered.
Yes.
Lordship, in the morning, I have prayed for upgradation of item 66. Lordship was pleased to allow the upgradation, Lordship. If Lordship pleases.
No,
to-
I said that we'll try to see.
Yes, yes.
Can be
Lordship.
adjusted.
If Lordship, only it's a small Lordship, the delay is of much higher than 500.
Delay condonation.
Yes, Lordship.
Delay condonation.
Yes, Lordship. Because of delay, the revision could not be listed and the conviction is of only 3 months, Lordship.
This check bouncing.
No, Lordship. Under section. Under section 147, 148, 149, 447, 506, 326.
Not be 66 to live up. Could not, 66.
66, Lordship.
Could not be taken up due to paucity of time. Learned counsel, however, submits that. If the revisionist is challenging his conviction and sentence and sentence is of 3 months,
In total,
3 months in total. And due to the pendency of the IA, within bracket, delay condonation petition, the criminal revision is not being able to be taken up by the court. It's the matter on, when should I fix it, this matter? This has some urgency.
Lordship, on 28, if possible, Lordship.
28 I can fix.
Yes.
This has some urgency.
Yes, Lordship. Yes.
You should have mentioned that aspect to me in the morning. Anyway, never mind. No, because this 3 months will pass. otherwise. This
And
one,
Lordship,
28
actually,
can-
they are not behind the bars.
I know.
They are outside, but the difficulty court has
Might
warrant.
become infractions.
Yes, yes, Lordship, there is a
Because-
difficulty.
Okay, they are not they are not inside the bar. I
On-
thought they are inside the bar.
No,
They are
no,
not
no,
inside
no,
the bars.
they are not inside.
Then you
the
have
bar.
some flexibility. Still, list
On-
it on 28.
2810, Lordship.
Learned counsel submits that the endeavor may be made to, endeavor may perhaps be made to take up the matter on or around 2 p.m. No? That we'll try. to
Yes,
take
yes,
up.
Lordship. Highly obliged, highly obliged.
Lordship, item number 53 is a transfer petition, Lordship, for transfer of a case filed under the Protection of Women from Domestic Violence Act, Lordship, from the district of Dhubri to Kamrup Metro District, Lordship. Lordship, today only I was supposed to pray for stay of that proceedings lower court pending before the learned court below, Lordship. So that Lordship, the
Next,
petitioner may
paucity
effectively,
of time,
a short date may be fixed, Lordship.
fix on 311.
Yes.
311.
No, state of Assam is not a party in this.
It will be required. And another, Deepur Seal and another.
Yes.
Another is state of, have you made the state?
No,
of-
Lordship, respondent number 1 is the husband of the petitioner and 2 is the mother-in-law of the petitioner.
State will be required.
Transfer petition, Lordship, not required.
Matrimonial matter.
Yes, Lordship.
Domestic violence. Okay, next.
I beg to mention item number 55, Your Honor. List, matter may be listed on 28.
It depends, you know, how many matters are, let it be thereafter. Yeah.
28 already your Lordship
Lot
has
of matters
fixed
are
many
there.
other ones.
So we don't know how many matters will be.
Then fourth, Lordship, fourth,
66.
611.
obliged.
56.
May
No,
be there.
What about 54? 54 is there? Nobody for 54.
I am for the applicant in the 54. So Lordship, that may be taken up in any date in the next, as per the convenience of this honorable court.
This is the matter, paucity of time, list after 2 weeks.
So a date may be fixed.
Some dates, no, some dates registry should also fix. Because they've instructed, I've discussed with them, because the thing is that otherwise we'll have an unmanageable list. We do not know how many matters would be listed.
Already, my lord.
So they make a proportion, actually. List after 2 weeks. If it does not come, then you can make a mention.
That's okay.
May I please also, I beg to mention item of 57. Then any date may be fixed in the next week, my lord. Today is the date fixed for consideration of interim prayer.
Very good.
Laws.
Paucity of time, list the matter after 10 days. After 10 days. Then next.
Lordship, my lord, I beg to mention item number 58, my lord. There only, my lord, I have an interim order till today, my lord. So that may be fixed and, my lord,
Interim order shall stand extended
continue
in the
in
next
IA,
week
my
of
lord.
district.
In IA,
List the matter after 3 weeks.
my lord, highly obliged.
May please, your Lordship. Lordship, in respect of item number 66, Lordship, I seek apology before the honorable court, Lordship. Conviction is of not of 3 months, but of 1 year, Lordship. I am sorry, Lordship.
No, it's okay. 3
You-
months, no, 1 year.
To
And they're
do-
outside.
Yes,
so
yes,
it's good.
yes. I am
But
sorry.
still,
Lordship.
we'll-
Yes, yes.
Just, one thing I forgot to ask you, the notice, everything is complete.
Lordship, on last occasion.
Because otherwise we'll
Yes, yes,
we'll
yeah.
not be able to dispose of the
Yeah,
delay
notice
condition.
was issued to the informant, Lordship. That report come answered. Then notice was issued through the concerned police station. And that was not received till that, Lordship, as per office note, Lordship. That is.
Because otherwise we'll not be able to
Yes,
proceed,
yes, Lord,
right?
that is also.
We'll be
true,
stuck,
Lordship.
actually. Kindly check the record.
Yes,
the next
I
day.
have checked.
That day you check,
Yes, Lordship.
and then if it is not ready, then
Yes, Lordship,
cannot
that will be
help.
difficult. Only, Lordship, if some protection may be granted on last occasion, matter was decided for Honorable Justice Miru Palda, sir, then was supposed to grant me some protection, but So that was answer to directed me to take steps to officer in charge of the concerned police station.
Yes, yes, that service of notice has to be there.
May I please, your lordship, I beg to mention item number 59, lordship. There is a IA, lordship, for substitution of the interim resolution professional in place of the suspended management, lordship.
Okay. Substitution, so 15, when do you want it? List?
Next week, lordship,
No,
anything.
no, after 2 weeks. List after 2 weeks, okay.
Lordship, can it be on 3/11, lordship?
We have fixed many matters actually on that day. Let it be on 7/11.
Okay, lordship, much obliged.
You know, all dates we should not fix because it will jam. We should leave some dates to the registry also. Because otherwise it will have disproportionate lists. Anyway, next. These are connected matters. 59, 60, 61, connected
No, no.
matters.
59.
WPC.
Connected matters,
Yes,
lordship, yes.
connected matters. Connected matters.
Yes, lordship.
Connected matters. Okay. একেলগে আহি পঠিয়াম। List on 7/11.
Much obliged.
May I mention? For the item number 56, it was fixed, and on last occasion, it was asked the prosecution side to take the instruction that whether the notice was been served or not. And
Okay.
as of the online tracking status report, that the same has been delivered.
Checking status one ki registered post news.
Register.
But here, matlab, from the police station, matlab, I will get the instruction.
Instruction is not come.
Not yet received.
57, 56, paucity of time. This is the matter. After 2 weeks.